Deputy Laura, could you mute us for a moment? Just one
I'm
moment.
probably only 45 minutes. I was saying, it seems like after COVID, I've seen a whole bunch of weird juries,
Yeah.
Just seems.
All right, everyone, we're going to go on the record. Jackets required.
Nope, sorry, Judge.
Sorry, that's a little.
That's okay. I know it's hot in here. It's very hot. All right, court is going to call 2019 CR 10921, State of Texas versus Brandon GUZMAN. Could I have parties announced for the record for the state?
Jason Jorgens and Daniel Escobar for the state.
And also Jason Gearham?
Yes, he's not present in the courtroom, but yes, Judge.
All right, for the defense?
Robert Mauer, and attorney Trey Mauer for Mr. Guzman.
And are you Mr. GUZMAN? All right, it's the court's understanding that you're proceeding on cause number 2019 CR 10921. Is that correct?
Yes, Your Honor.
All right. The jury is out in the hallway. The following jurors are not here. Jurors number 9 and jurors number 51. Any objection to proceeding without those two jurors? State?
No, Your Honor.
Defense?
No, Your Honor.
All right, then, Deputy Mejia, if, of course, jurors number 9 and number 51 appear, state and defense, we will have them come in and we will do those by specific voir dire. Are both parties ready to proceed with jury selection? State?
No, Your Honor. The state's requesting a jury trial.
Any objections? Which there are no objections, but any objections?
No, Your Honor.
All right,
Even
so.
if I could, I wouldn't.
All right, so we will have the jury selection done. It'll probably take about 15 minutes, maybe. Thank you. All right, thank you.
You got, okay.
Good Lord, I like this Michael McFarland guy answering nothing.
All right, so we're going to go back on the record. In 2019 CR 10921, the jury shuffle has been completed. The court has been informed by the deputy that jurors previously marked as 9 and 51 are now present. Are both parties ready to proceed?
Because I'm not ready. I need a couple minutes to go through this. I got here early and everything ready to go, and then the statement seriously asked for a couple minutes to my morning up.
All right.
Is that on the record?
Hopefully.
Yes, that's on the record. All right, you can move us.
It's voice to that now. Being introduced. Stand up as well.
Be the first row at the end. Number 69. Okay, will be the second row on top. You can have a seat. Please sit down. We stand for you. Number 3. 1. Okay, 2, first row. What is the first row bed? Okay, 16. Okay, 16. 16.
And everyone, there are numbers in your chairs. Don't sit on them because you're going to need those.
Thirty.
31.
Number 30. I guess we're number 30.
There was a 30.
37. Number 37. Next round. 37.
38.
You put yourself.
Yeah, stop that. You're 32. Make sure you're.
What time? 46, 47. Next row. 51. Next row. 55. It's 59.
Okay.
Is there a 30 then? Yeah. Okay, making sure. Thank you. Make sure your phones are on silent mode.
All right, everyone, please be seated. Good morning, everyone. Okay, that's a week. Good morning. And the thing about it is it's Friday. So good morning, everyone. All right, that is awesome. All right, I'm glad you all made it back. I saw you in the hall yesterday. And as I explained then, the reason why you were ordered yesterday is because jurors for us are not available on Friday. So we have to order them the day before in order to have a panel. All right, so you are in the 187th District Court. I'm Judge Stephanie Boyd. You're on the 4th floor. 187 District Court, Judge Boyd, 4th floor. So where are we? Oh, that just fell off. Like when you sing Old Lang Syne, everybody knows the first 2 verses, then everything's dropped. All right, so what's the courtroom number? 87. And who's the judge? All right, see, thank you. You got the first name too. I appreciate that. Now you're probably asking, why is she asking us to say that? The reason why I asked you to say that and repeat that is because we cannot complete jury selection unless you're all here. And sometimes we end up taking a break. And when we take a break, sometimes we're waiting for people to come back and everybody's like, where did that person go? And one time we had someone who ended up trying to go on another jury down the hallway because they got the wrong court. And then one person said, I looked up and everybody was gone. I didn't know where to go. So I always have people to repeat that because there's only 187 district court and in both courthouses. And I'm the only Judge Boyd of all the judges in the courthouse. So if you know any one of those two things and you get lost, someone will be able to direct you to this court. This is a case involving the state of Texas versus Brandon GUZMAN. For the state, who do we have? If you could introduce yourself, please.
Morning, my name is Jason Jorkins.
And I'm Jason Garahan.
And I'm Daniel Escobar.
So the room is small, so you can see we have people spread out. For the defense,
Robert Maurer for Brandon Guzman. Trey Maurer,
Robert Maurer.
Brandon Guzman.
all right. All right, so I'm gonna come back around and ask you some questions about the parties you've just been introduced to. But before I do that, I want to draw your attention to the court reporter. Can you raise your hand for them, please? All right, this is the court reporter. She takes down everything that everyone is saying. And I always say, if you can make somebody's job easier and still get the job done, then let's make their job easier. So how can we make her job easier? By talking loud, right? So that she can hear, because she has to take down everything that everyone is saying. And if you can realize, everybody speaks at a different pace. Some people are whisperers. And so that makes it hard for her. So I'm going to ask everyone in the box, please raise your card. Keep them raised. Up, just the people in the box. Everybody on this front row, raise your card for me. All right. So the other people who don't have your cards raised, if your card is not raised, what that means is whenever you answer a question, if you can, you'll need to stand so the court reporter can hear. I have so far had no jury follow that rule, but I have faith that this jury will follow that rule. So if your card is not raised, please stand so when you talk, she can hear you. All right, you can lower your card. Now, I've had the parties introduce themselves. Is there any one of these parties that anyone here knows? All right, juror number 37, thank you. Anyone else? Juror number 3. All right, juror number 37, who do you know? All right, so see, I had faith in you all disappointed me. All right, juror number 37, we'll pretend like that didn't happen. So we're going to start over. Juror number 37, who do you know? Okay. Juror number 3, who do you know?
Judge Garahan.
Okay. Now, I know you all got a chance to meet each other in the hallway yesterday. You probably met each other in the central jury room, and you probably met each other in the hallway again. So is there anyone here who knows anyone on the panel other than just meeting them in the hallway or in the central jury room? Number 41. All right, since 41, just a second, since 41 says they know someone, there should be a corresponding person. We're going to find out who 41 knows. 41, who do you know?
Curtis Finney.
I'm sorry, who?
Curtis Finney.
Who's Curtis Finney? Number 38. I cannot believe you didn't raise your card. Why not? All right, how do you all know each other?
Colleagues from work,
Musician friends.
clients.
Okay. All right, thank you very much. Anyone else know anyone? Number 16.
Gabriel.
Who's Gabriel? What's your number?
Number 9.
Number 9. All right, 16. Number 9 is being shy. How do you know number 16? I mean, how do you know juror number 9?
We're colleagues from work, but shifts.
Colleagues from works where?
McDonald's.
Okay. All right, McDonald's needs to bring back their Cajun fries. I'm from Louisiana, I'm just saying, okay? All right, anyone else know anyone? Number 12, who do you know?
I know, Darcy.
What's your number? All right, why are people being shy, not admitting they know people? How do you know each other?
Well, he knows my husband, he's a friend of mine.
Okay, all right, thank you. Anyone else? All right, this is a lot of people who know each other. One time we had the wife and ex-wife, they knew each other. But it went very well. It went very well. All right. So this is what's called jury selection. I'm going to ask you some questions. Then once I ask you some questions, the state will get a chance to ask you some questions, and the defense will get a chance to ask you some questions. The questions that are being asked are not designed to embarrass anyone, so please don't take it that way. When we ask you questions, this will be the only time that the defense or the state or myself will be able to ask you questions. So please make sure if there is anything that applies to you, just raise your card. Raise your card. Once someone calls your number, you can lower your card. The charge in this case is a murder charge. So I'm going to let you think about that, and then I will cycle back around to that. When the state speaks to you, when the defense speaks to you, when I speak to you, it's all about hypotheticals. Neither the state nor the defense are allowed to speak to you about what they think the facts are in this case. The only time you'll get to hear evidence or what parties believe the facts are if you are on the jury. Does everyone understand? Yes. All right. Now, how do we get here? The way a case is brought in felony court is by indictment. And an indictment is just a means whereby someone is given knowledge that, one, you have this charge, two, this is where you need to answer for it. And when I say answer for it, it means to be heard about it. For example, how many people here have had a traffic ticket? Remember, I'm testing you with raising your card. All right, there are some people here on the front row here who've never had a traffic ticket. Congratulations. So I've had one traffic ticket in my life. At the young age of 21, which is my current age, not. But I had one traffic ticket when I was very young. And during that time, when they would give you a traffic ticket, the officer had a ticket book, and they write on it, and they get the carbon copy, and they give you the other copy. When I accepted that ticket, I wasn't saying I was guilty of it. That was just me saying, okay, what are you saying I did? And where do I need to be if I want to go to trial for it? So, of course, in San Antonio, sometimes people don't know what the yield sign means. Lately, people don't know what the school zone means. But let's just say you get stopped for failing to yield appropriately. The officer will give you a ticket. When you accept that ticket, you're not saying, yeah, I did not yield. What you're saying is, okay, you're saying this is what I did. Let me see where I need to be, what date I need to be there. And then you go, and at that time, either you have a jury trial or you do not have a jury trial. So indictments are not evidence of guilt. It cannot be taken to mean anything. Does everyone understand? Yes. Is there anyone who's going to hold it against Mr. Guzman because he's been indicted? All right, the next thing I want to talk to you is about some constitutional rights that everyone who's accused of an offense has. How many people have seen Beretta, Mannix? Oh, see, there's some people who have. Thank you. Own it, own your age. The paper chase, the practice, Suits. All right, that should cover all the age groups. Matlock. Thank you. That's in rerun. So if you haven't seen that, I don't know what you're doing. So certain rights that people have, one is the right to remain silent. So what that means is No one in a criminal case can call you to testify. Now, there are many reasons why someone may not want to testify, many reasons why someone would remain silent. Sometimes people are afraid of speaking in public, and it's a very difficult thing to do, especially when you're speaking to strangers. Sometimes people may stutter. Sometimes people's attorneys may say, oh, you don't need to testify. Nothing has been proven. There are a host of reasons why somebody would not testify, but you are not allowed to make assumptions or consider it at all or use it at all as evidence against anyone for not testifying. In this case, if Mr. Guzman decides not to testify, is there anyone who will consider that against him or hold it against him for not testifying? Okay. The other thing is everyone is presumed to be innocent. So what that means is unless and until the state presents evidence that proves their case in each element beyond a reasonable doubt, that you must find the defendant not guilty because they're presumed to be innocent. Now, if the state proves their case, then that's something completely different. Now, with the presumption of innocence, that means that the state has the burden to prove their case. The defense does not have to prove anything. We would always say in law school that you could read a newspaper, you could play crosswords, you could go to sleep because you don't have to prove anything. Does everyone understand? So the burden never shifts to the defense. The burden is always with the state. So sometimes when people are deliberating, because I've been a prosecutor and defense attorney, there are always, sometimes jurors will say, well, I wonder why the defense didn't present this, or I wonder why the defense didn't do that. They don't have to prove anything. So the burden always rests with the state. Now, what is the burden of proof with the state? It's proof beyond a reasonable doubt. What does that mean? When I graduated from law school, everyone had to know the definition of proof beyond a reasonable doubt. I knew it backwards and forwards. And you feel so great when you've learned that definition and you could say it without stumbling on the words. Had my first jury trial as a defense attorney. And after that jury trial, guess what? There's no longer a definition for proof beyond a reasonable doubt. It was taken away. So neither the state nor the defense can tell you that definition because there is no definition for proof beyond a reasonable doubt. So the way I would explain it to jurors when I was a prosecutor and defense attorney, I would explain it to them by telling them what it is not. Next door, there's the historic courthouse with the green rooftop. They try civil cases over there. So when there's issues with money, the burden of proof is usually preponderance of the evidence. More likely than not, something happened. That burden is lower than proof beyond a reasonable doubt. The other burden they have over there, which is one of their higher burdens on the civil side, is clear and convincing evidence. Clear and convincing evidence is the burden that is used to terminate or take away someone's parental rights to their child. They say, you're a danger, you're not a fit parent for your child, so they take away your parental rights. That burden is lower than proof beyond a reasonable doubt. So this is the highest burden that we have. Now, there are two phases to a criminal trial. The first phase is determining whether someone is guilty or not guilty. A lot of people think that phase is innocent or not innocent, but really it's not. The first phase is either you determine someone's guilty or not guilty. If you determine someone is not guilty, there's no phase two. Phase two is what's called the punishment phase. If you determine someone is guilty, then you go to phase two, which is the punishment phase. In Texas, it's required that if someone is going to a jury trial, before the start of trial, they have to make an election or determine if they were found guilty, who would decide the punishment. By them making that election, they're not saying they're guilty. It's just that the law requires that they make an election. Does everyone understand? Yeah. In this case, Mr. Guzman has decided if he were to be found guilty, he would come to the court or me, the judge, for punishment. Is there anyone who's going to hold that against Mr. Guzman? Okay. Now, I want to talk to you about the one witness rule. It's very important. When I talk to you about this rule, do not add anything to the fact scenario. So don't add anything. As my grandmother used to say when she was alive, don't add anything, don't take anything away. So this is the fact scenario. A witness comes in to testify. There is no problem with that witness's vision. Vision is perfect. There is no problem with that witness's credibility. You believe the witness. You're not in your mind thinking, well, maybe they saw it differently. Well, maybe they were wrong about this, or maybe they were wrong about that. The fact scenario I'm giving you, it's one witness, they're credible. Maybe it's Mother Teresa, but they're credible. You believe everything that they're telling you. And what they tell you proves the state's case beyond a reasonable doubt. All right, everybody have that fact scenario? So there's no question in your mind that that person is telling you the truth. No question in your mind that they've proven the state's case. Does everyone understand? All right. So I want you to hold that fact scenario in your hand for me. And I'm going to talk to you about if someone, let's say someone's, hypothetically, someone is robbed, right? There are two people, the defendant and the person who was robbed. The person who's robbed comes in and testifies and says, yes, that's the person who robbed me. This is the date they robbed me on. This is what they took from me. Here's the question with regards to that scenario. Is there anyone here who thinks that that case should not be brought to court because there's only one person to say, this is the person who robbed me, this is what they took from me? Anybody who feels like that case should not be brought for trial? All right. So now let's go back to my first fact scenario. Witness testifies. Witness is credible. You believe that witness. That witness proves the state's case beyond a reasonable doubt. It proves every element, proves the date, proves it happened in the particular county it was alleged to have happened in. It proves this is the person who did it. It proves this is what it's done. Is there anyone here who would not be able to find someone guilty based upon that one witness? Okay. Now, the next thing I want to talk to you about is with regards to languages. I love languages. I think they're great. I had no idea I would end up in Texas. Sometimes your life takes different turns. So in middle school, junior high. It was junior high when I was growing up. Now it's called middle school. So in junior high, high school, undergraduate in college, graduate school in college, didn't know I would be here. So what's the language someone from Louisiana would take when they have dreams and stars in their eyes? Of course, it would be French. And then I ended up in San Antonio, and I realized I should have listened to my friend Tanya when she said, Stephanie, let's take Spanish. But I didn't. And then when I went to law school, all of the students who were different countries could speak like 4 or 5 languages. So I know how to say the words hurry up in probably every language because that's the only thing that stuck with me. And I said, why can you all teach me something that didn't sound sort of rude? So this trial, of course, is going to take place in English. Is there anyone here where English is not your first language? If you'll raise your card for me. All right, 67, 12, 59. Anyone else? 70. All right, juror number 12, where are you? All right, what's your first language?
Arabic.
Yalla. That's what Laura taught me. That's all she taught me. Did I do okay with that?
Yes.
All right, and I mean no harm in telling you to hurry up. Thank you very much. Have you been able to understand everything that's been going on?
Yes.
All right, thank you. 67.
Spanish.
Spanish. Have you been able to understand everything?
Yes.
All right, thank you. And how do you say hurry up in Spanish? You have that? The court reporter does not like it when I ask people to speak other languages. Number 59. All right, and have you been able to understand everything? Thank you. Number 70. I thought so, but I didn't want to assume. Thank you. All right, the next question I want to talk to you all about is travel arrangements and time constraints. We never can say how long a jury trial is going to last or not, but as you all know, Good Friday is coming up. So we don't have court on Good Friday, and I won't have you all down here on Good Friday. So this trial may go into Monday or Tuesday, just so people have some idea. So I want to talk to you about travel arrangements. Is there anyone who has a trip plan and they cannot, change it, cannot give the tickets to me? Is there any situation like that? All right, 31. What is your travel arrangement?
Washington, DC on the 6th, coming back on the 10th.
All right, what are you doing in DC?
Take the kids to go see the sights.
All right, do your children want you there? How old are they?
Well, they need me there to check into the hotel. But it's
Okay.
19, yeah.
Okay, all right, thank you so much. Anyone else? Now's the time to tell us. All right, any other time constraints for anyone?
What? I have to be at a doctor's appointment. I can't change for a heart condition on the 5th, so Wednesday.
Okay, April 5th?
Yes.
Anyone else? All right, see, once you start, then everybody says, oh, no lightning struck me, I can raise my card. All right, number 7.
Well, I can make it work this Monday and Tuesday. I just have an appointment I can't change on Wednesday, and then the next weekend I will be traveling, but this Tuesday and Monday should be.
All right, so you can't change your appointment that's on the 5th?
Yes.
Okay. And where are you traveling?
With my husband to actually close to Louisiana.
Oh.
He's from Louisiana.
Oh, see, I know he's a great guy then. What part of, what part of Louisiana?
We'll actually be going to Opelousas as a grandmother.
Ah, okay. I'm originally from Shreveport and people tell me, no, you're too close to Dallas. You're not really in Louisiana.
Yeah.
All right. And so you can't change April 5th. Definitely. You need to be there on April 5th. What time is that?
Well, I have an ultrasound appointment.
Okay, no.
that I pushed back. So that would be like in the morning on Wednesday.
Okay, Wednesday morning. All right, number 40.
I'll be traveling the week of that Thursday, the 13th. I don't know if that would.
All right, where are you heading on the 13th?
That's
Odessa, Texas. What are you doing in Odessa, Texas?
my daughter coaches and teaches there, so she's coaching softball right now. So it's softball season, and we've already had made this 2 months ago.
Oh, well, you have to be there.
Sorry.
I said you have to be there then. All right, thank you. And that's the 13th.
Correct.
All right, number 37.
So be traveling on the week of the 13th,
And where are you headed?
Virginia.
What are you doing in Virginia?
My partner's in the military and in a training, so I'm going up to.
All right, awesome. Number 27.
I have to go to Virginia on the week of the 13th.
Are you all traveling together?
No.
All right, what are you doing in Virginia?
Going to see my granddaughter.
Oh, thank you. Anyone else? 28.
I have something on the morning of the 6th, an appointment I can't miss,
Okay. What time is your appointment?
8:40.
And how long do you expect it to last? I know. Okay. All right. Anyone else? Okay. So I'm going to tell you all 2 true stories. I know that people sometimes don't want to come for jury duty. I really appreciate the fact that you all came yesterday and came back today, because I realize downtown parking is high. There's so many one ways, and then there's construction. But I always tell people your country doesn't really ask a lot of you. You don't even have to vote, which I'll get on my soapbox about that at another time. But you don't have to register to vote. You don't have to vote if you don't want to vote. You don't have to do any of that. And just so you all know, sometimes people will come into court and they come to the wrong courtroom. It has absolutely nothing to do with this court. Sometimes people come in through that door and they don't read the sign that says we're in jury selection, don't come through that door. And then they see everybody and they're like, oh. Now the people who are coming through this door are people who are on my staff and they have documents for me to sign. And those documents that I'm signing have absolutely nothing to do with this case. And because I'm going to be presiding judge next week, you may see officers who come through this door. Again, that has absolutely nothing to do with this case. Sometimes I have to review search warrants and that type of thing. So ignore that. All right, so your country doesn't ask a lot of you. You don't have to vote if you don't want to vote. You don't have to register to vote. Somebody tell me, yeah, we have to pay taxes. Okay, you have to pay taxes. And you have to come down for jury duty. And it's not even you're coming to jury duty every month. And I always tell people this because I know that people, sometimes you get a little frustrated because we're waiting long. We don't have this, we don't have that. But I want to tell you about my uncle. So my uncle grew up in Grand Cane, Louisiana, small town. It was even a small town in its heyday. And super intelligent. He's since passed, but super intelligent. So all of the teachers would end up skipping him grades up. Now, his sisters didn't like that much because he was super intelligent. So all the teachers would tell them, you got a lot to live into. So when he finished with school, the Vietnam War breaks out, right? He's just graduated. And everybody, all the boys in Grand Cane are being drafted. So he tells my grandmother, look, I want to do things with my life. I know I'm not going to be able to do things with my life here. I'm just going to go ahead and go. And so my grandmother, because he was young, had to actually sign for him to go. Now, if you can imagine, that's her firstborn. She's sending him off to war, may or may not come back. If he comes back, maybe he's not going to come back and be the same person that we knew. And so she signed for him to go. And the reason why I tell everybody that story, because in the big scheme of things, that sacrifice, that takes a lot of you, right? So when your country asks this small a thing of you, there are other sacrifices that are greater. Of course, my uncle ended up coming back from Vietnam, but everybody was still worried about him. Sometimes the letters sent to him didn't get to him. And, you know, he's wondering, have people forgotten about me? So that's one story. And I tell everybody that because this is what your country is asking of you, to serve on a jury. The other story I'm going to tell you is about a friend I have from law school. And she's the friend who taught me some Arabic. She decided to do civil work. So on the civil side, and I've done civil as well, you're not in jury trial as much. Usually it's a lot of paperwork. And we hadn't got a chance to spend time with each other since law school because I'm in trial all the time. She's doing her civil work. So she calls me because she says she's up for jury duty. And I said, great, we can have lunch together. She's like, yeah, that's what I was thinking. So during her break, we have lunch. And I said, how's it going? And she's like, it's going fabulous. Now, mind you, I'm thinking, how can it be fabulous? It's not like you're in the 187th with Judge Boyd. So how can it be fabulous, right? So she tells me it's going fabulous. And I said, why do you say that? She's like, oh, I'm not going to get selected. I'm like, what do you mean you're not going to get selected? She's like, it's like when we're in law school. She's like, I'm sitting at the back, keeping my head down. And so I started laughing at her. And she said, what's so funny? I said, the people who are silent are always the people who get selected. And then I see her at the end of the day. And she looks at me. She's like, I'm on the jury. I'm like, great, we get to spend lunch together for the entire week. So I tell that to you all to let you know, both the state and the defense want you all to speak up because what they're trying to do is trying to get a fair jury for this trial. Okay? Now, the other thing before I turn it over to the state, if any of you ever need a break, just let me know. This is the break sign. Let me know and we will give you a break. But when we take a break, everyone has to leave the courtroom so no one can stay behind. And when we take a break, if you want to leave your personal items in here, you can, because we will remain in here, or the deputies will be here as well. So you can leave your items behind. Everyone understand? All right. To defense and state, I want to remind you all, I wear glasses. Some people here are wearing glasses. We can only hear, when you wear glasses, people who wear glasses will understand this. We can only hear when we actually see people, and it helps the court reporter if you all don't stand in front of the people you're talking to. All right, with that being said, state, are you ready to proceed?
Yeah, sure. If I could just get the PowerPoint.
Yes.
May I please report?
Yes.
How many of you guys were excited when you got your summons for jury duty? I see one, I think it's number 3 down there holding up her hand very low. And then number 55, all right, a couple out of 75, that's about what we tend to expect. We know that for most of you, this is not what you want to be doing on a Friday, but like the judge said, this is an important duty as a part of your role in this country. And we understand that this is taking time out of your life. So we do appreciate you being here and helping us get justice for this case. So let's talk number 3. So the hesitantly excited for her jury summons. Ma'am, did you drive to get here, or did you take another form of transportation? You drove? Okay. So let's say hypothetically, all the stuff today will be hypothetical. All right. We're, like Judge said, we're not getting into the facts of the case. We're just talking about hypotheticals to try to get your sense of the law and kind of your reaction. So let's say number 3, and I'm going to address you by your number, just to try to keep some anonymity in front of your new 74 closest friends over here. Let's say you got up this morning, you were tentatively excited for jury duty, and you go out to your car and you find that overnight it had been broken into. So someone smashed in the window, someone went in, stole your stereo, stole whatever property you had in the vehicle. And then you get here and you find out it's not actually a murder trial. You're actually here for a burglary of a vehicle case. Now, in a situation like that, with a similar crime having just happened to you, do you think it might be a little bit difficult to be fair and impartial if you were to sit as a juror in that kind of case?
Perhaps.
A little bit, right? Or it could potentially be. I know it would for me if it happened to me. And ultimately, that's what we're trying to get to for jury selection. We're trying to find the 12 to possibly 14 best jurors for this particular kind of case. So if anyone has any biases or any, I guess, preconceptions that could affect your ability to be fair to both parties in this case, both the state and the defense, that's what we want to get at today. All right. So if you can just be honest with us, that's all we're asking for. There's no wrong answer here. We just want to get your thoughts and your opinions. Okay. All right. I'm seeing a bunch of nods. So I like doing jury selection in the morning because everyone's a little more awake than if we did this after lunch. So let's talk. Judge mentioned the trial process. So generally, right now we're at jury selection. We will narrow these 75 people down to 12 to 14 jurors to sit and listen to the actual evidence in this case. That's in the guilt or not guilt phase of the trial. If you return a verdict of guilty, then we move on to the punishment phase, and it's a separate phase of trial. And you heard the judge say that Mr. Guzman has elected to go to her for punishment in the event that he's found guilty. That's not saying that he expects to be found guilty. It's just something that is required. But what that means for you all is that if you do return a verdict of guilt, you will not be the ones assessing punishment. So if I can see a show of cards, does anyone have a problem with that? Is there anyone who says that if I'm finding someone guilty, I would need to be the one to assess punishment? Like I couldn't, in good conscience, return a verdict of either guilt or not guilt in the case, knowing that I would not be the one to decide what the appropriate punishment was. Can I see a show of cards? I guess we'll go one section at a time. So this big section over here, can I see any show of cards? Anyone who feels that way, or anyone who has a question about that? Not seeing any cards. And over here in the smaller section, show of cards, not seeing any cards. And over here in the more comfortable seats, the jury box, any show of cards? No, no cards. All right. Does anyone have a question about the trial process? Off the bat? No. All right. So let's talk about some of the rights that the parties have. And you heard Judge go over a bit of this. So as the state, we receive evidence from law enforcement agencies. So we review that evidence. If we seek out new evidence, we can subpoena evidence, we can subpoena witnesses to talk to, or subpoena witnesses to come up on the stand and testify in trial. And then also we have the right to a jury trial. Now the defense, you heard Judge talk about some of their rights. Mr. Guzman, as any citizen charged with a crime, has no burden of proof. He's not obligated to present any kind of defense. Does anyone know why that might be? Anyone have a guess? Why is someone accused of a crime not required to present any evidence? Number 7, tentatively. You guys gotta be proud of your number. All right, number 7. Why do you think that is?
You're innocent until proven.
Yes, yeah. So you're innocent until proven guilty. And beyond that, who do you think brings the charges for a case? Who brings criminal charges?
Whoever the plaintiff is.
Yeah, I'm hearing a couple of people saying it. Yeah, the state. So my office brings the charges. So isn't it fair that if we're the ones that are accusing someone of a crime, that we have to prove it? Because like you said, there's a presumption of innocence. So he is, as he sits here right now, Mr. Guzman is presumed to be innocent of the charge. All right, and everyone's comfortable with that. I'm seeing some people nodding. Oh, I'm sorry. Sorry about that. I get excited about jury selection. I like doing this. So, all right, I'll try to take it a little slower. So, right. So we're bringing the charges. There's a presumption of innocence. So the defense does not have to do anything. Now, they're good attorneys. I expect them to talk and to question witnesses, but they don't have to. There's no obligation for them to do that. There's also Fifth Amendment right not to testify. And you heard Judge talk about that. And presumption of innocence, as you just covered. Now, the defense actually has additional rights beyond those that I have listed in the box. They actually have some of the same rights that we have as the state of Texas. Does anyone want to take a guess on the left-hand side of the screen? Which rights might a defendant have? Should they fall under the state's category? I'm sorry, number 6.
The right to review evidence.
The right to review evidence, right? They are allowed, because we're the ones bringing the charges, they're allowed to review all the evidence that we have against Mr. Guzman. Does anyone want to take another guess?
The right to a jury.
All the, I heard someone say it. Who said all the others? And ma'am, what's your number? 58. Right. So all of the rights that I have listed up here that are under the category of the state, the defense has all those rights. Now remember, they do not have a burden. They do not have to collect additional evidence. They do not have to call any witnesses. But if they choose to, they can. And most importantly, they review all the evidence. They know exactly what evidence we have against Mr. Guzman. So now that we talked a bit about the rights, let's talk about the burden. You heard Judge talk about it beyond a reasonable doubt. The burden rests with the state. It's always with my office. The defense does not have to prove anything. And because they don't have to prove anything, he can choose not to testify. But let's talk about a bit about what that burden is. So let me, I haven't talked to a lot of people on this side. Sir, what's your number? 46. All right, sir, do you see that flag over to the, I guess you're left of the judge. Do you see that over there?
Yeah.
What flag is that?
American flag.
Now, I don't want to put words in your mouth, but do you believe that that's an American flag beyond a reasonable doubt?
I do.
Do you have a reasonable doubt about that being the American flag?
No,
Why not? Why do you believe that that's the American flag?
because that's what the American flag looks like in my experience, which is extensive with flags.
Sure. So
American flag.
now hold on a minute. The American flag, correct me if I'm wrong, but I think it has 50 stars, right?
I believe that's the latest number, yeah.
Yeah, the latest number. We'll see about Puerto Rico maybe at some point, but 50 stars and it's got 13 stripes, right?
I think that's true.
Now, from here, from your position, again, correct me if I'm wrong, but you can't count all 50 stars on that flag, right?
I cannot,
And you can't count all 13 stripes.
I cannot.
But you still say because of your past experience with American flags that you believe that that's the American flag beyond a reasonable doubt.
I do.
Because you've seen past flags, right?
Yeah.
And we're in a courtroom. Hopefully we have the correct flag in a courtroom in the United States, right?
Yeah.
And you can see some of the stars. Yeah. And you can see some of the stripes.
Yeah.
But the only way that you would know 100% is if I went up there behind the judge, which I'm sure she would not like. If I went behind the judge and I held up that flag, and so you could count all 50 stars and all 13 stripes, right?
That would be required to 100% confirm.
Oh, if you could speak up a little bit louder.
That
You-
would,
All
that
right,
would be
see,
required to 100% confirm that.
If you can stand.
Yeah, if you could stand when you're answering the question. Sorry about that.
Yes, sir.
So you said that would be required to be 100% confirmed, right? But so our burden is in the case is not beyond all possible doubt, right? It's beyond a reasonable doubt. Does everyone understand what the difference is? You can sit down, I'm sorry. Does everyone understand the distinction there between knowing something beyond all possible doubt and beyond a reasonable doubt? Does anyone have a question? Does anyone have a reasonable doubt that that's the American flag? All right. Now, and I'll move on. I'll go next door. Sir, are you number 45?
45.
All right. Now, number 45, if you knew beyond all possible doubt that an offense happened, we won't talk about the flag anymore, but that an offense happened, what would that make you for a case? If you knew 100% what happened? No. Let's say you know even beyond that. Yes,
Yes,
you know 100%. What does that mean? for you?
The court reporter cannot hear, and
Oh,
please do not stand in
sorry.
front of the person you're speaking with.
All right,
Thank
I'll
you.
stand all the way over here. Come with the guys in the jury box. What would that mean if you knew something 100%? Right, but what for the case that would make you a witness, right? The only way that you know something 100% is if you saw it happen. Is that fair to say?
Yeah.
Okay, thank you, sir. You can sit down. Now that we've talked about what the burden is, does anyone have any questions about it? Obviously, we can't define it as the judge said, but does anyone have any questions about what that burden is or what it means? Nope, not seeing any cards. You guys are starting to fall asleep on me. Don't fall asleep yet. Let's talk about what we have to prove. Now that we've talked about what the burden is, what do we have to prove? Generally, the elements of a case fall into who, when, where, and what. So in this case, there's actually two different paragraphs, two different ways that we've alleged a murder has been committed. The first three are generally pretty straightforward. We've alleged that Brandon Guzman, on or about the 29th day of July 2019 in Bexar County, Texas. Then we get into the what. We've alleged that he intentionally or knowingly caused the death of an individual, namely Justin Larrabee, by shooting Justin Larrabee with a deadly weapon, namely a firearm. That's one way that murder can be alleged in the state of Texas. And that's what you can see up at the top. It's labeled as paragraph A. So that's one alternative. The other alternative that we've alleged generally tracks the same basic elements. Brandon Guzman, on or about July 29th, 2019 in Bexar County, Texas, with the intent to cause serious bodily injury to an individual, namely Justin Larrabee, committed an act clearly dangerous to human life that caused the death of Justin Larrabee by shooting Justin Larrabee with a deadly weapon, namely a firearm. Now, because those are alleged alternative paragraphs, we can prove either one or both. There's 6 of you can agree that he committed it with the intent to kill Mr. Larrabee. 6 of you can agree that he was just intending to cause serious bodily injury, committed the act dangerous to human life that resulted in the death. Does anyone have any questions about that, about proving murder in the alternative? Both of those are ways to commit murder in the state of Texas. Not seeing any cards up. Sorry, I don't mean to turn my back on you guys. Yes, number 31. Yes, sir.
Isn't there like an intent and a non-intent? Well, my point is, doesn't that influence the sentencing? So
So-
for
so-
instance, if it's first degree murder, it's intentional murder. Sentencing maybe one way, but if it was accidental or maybe not intentional murder.
Sure. So let me take that one at a time and see if that answers your question. So murder is a first degree felony in the state of Texas. So regardless of which paragraph A or paragraph B, either way, it's still first degree murder. Yes, I mean, that to answer your question, that could influence sentencing, right? But remember, you guys are not, if we get to that point, you are not determining the sentencing for that. So that would be up to the judge to decide one way or the other how that would affect sentencing. But either way, whether it was the intent, and I'll back up a bit, whether it was intentionally or knowingly causing the death, or if we go forward, whether it was just intending to cause serious bodily injury that ended up resulting in death, either way, that's considered murder. That's still a first degree felony. And you look a little hesitant about that. Did that not clear it up?
No, I mean, that's clear. I guess I assumed that there was different degrees, but I know we're not involved with sentencing, but
Sure.
Yeah.
Yeah, so either way, that's considered murder. If you do either of those two things, that's murder in Texas, and it's a first degree felony. What is not on there? We got who, when, where, and what. I see number 59. What's not on there? Why, right? There's no motive. We're not required to prove the motive for the case under the law. Does anyone know, or does anyone want to take a guess why that might be? Why are we not required to prove motive? I see 26.
That's, I think, in my opinion, you're like assuming why he did it or
Right.
assuming why he did it.
Sure, we'd have to make assumptions, right? Because he is not required to testify. We can't force him to testify. There's no way to get inside his head and prove why he did something. Sometimes there may not be a reason, right? Is that fair to say? Sometimes we don't know. I saw number 43. Yes, ma'am.
Well, it was committed murder.
Sure. Yeah, and so if that's relevant, that could be a defense that's raised in trial. So that could affect the guilt or not guilt finding, right? And I thought I saw another card. No. I think, all right. So let's talk about that. So we're not required to prove motive. So we'll do a scale question now. So I want you guys, I'm going to go through one at a time, get your answers. So our burden is proving each element of the case, the ones that we just talked about, beyond a reasonable doubt. So if you believe all of the elements beyond a reasonable doubt, you would be able to find the defendant guilty even without knowing motive. Because remember, motive, why, that's not one of the elements. So we're trying to get a sense from you guys about how strongly you agree with that statement. So you believe the case beyond a reasonable doubt. Under the law, that would require you to return a verdict of guilt, even if we don't offer evidence of a motive. So I'm going to go through one by one. So number one, you're going to be in the hot seat first. Just remember. Number 5, you strongly agree. 4, you somewhat agree with that statement. 3, you don't know or you have no opinion about it. 2, you somewhat disagree with that statement. And 1, you strongly disagree with that statement. So I don't have any questions before we get started. All right, we'll go kind of fast. I'm just going to call out your number. And if you can just call out the number that reflects your opinion. All right.
Just one moment,
Oh, yes.
and I'm going to pause you. So to make it easier for the court reporter, because court reporters have an issue with the sliding scales, counsel, if you could, just have people raise their numbers if they're number 1, raise their numbers if they're number 2, if it's okay, if you would do it that way, because it'll make it easier for the court reporter.
Okay, Judge, do you mind if I do it 1 second at a time?
No, that's fine.
All right, so we'll do the same kind of group of sections. All right. Okay, so everyone in this section, if you can raise your cards when I call it out, and then when I call your number, you can put your card down. All right. So everyone who agrees with number 5, if you can raise your cards in this section at this time. Everyone agrees with number 5. I'll give you a couple seconds to think about it, get your cards out for a night. All right. So for number 5, I've got, nope, I got 2, 3, 5, 6, 8, 9, 10, 11, 12, 16, 17, 19, 20, 22, 24, 23, 24, 25, 26, 31, 32, 33, 34, 37, 38, 39, 40, 41, 42. All right, everyone who agrees with number 4, if you could raise your card at this time. All right, I see, I'll give you a couple seconds. I see number 1, number 7, 13, 15, 18, 21, 27, 28, 29, 30, and 36. Oh, and seven, did I call you? Okay, 7. And now number 3, don't know or no opinion. I can get you to raise your cards at this time. All right, I see number 4. And then the 2s, somewhat disagree with that question or with that statement. I see number 14 and 35. And then the 1s, strongly disagree with that statement. And I don't see any cards up. All right. We'll go a little bit faster now with this section. Can I see the show of cards for the 5? All right, I got 45, 46, 48, 54, 55, 56, 58, 60, and 61. And the 4s, you can raise your cards. I see 50, 47, 51, and 57. And 49 sneaking in at the end. No, that's okay. And the 3, I think on 3s now. 3s, if you can raise your card. I see number 53. And 2s now. Somewhat disagree. 43, 44, 52, and 59. Am I going too fast? Okay. And now the 1s. And I don't see any cards for 1s. All right, jury box. We're almost at the end now. The 5s, so you can raise your cards, please. All right, I see starting 62, 67. I'm sorry, 66, 67, 69, 70, and 71. All right, the 4s now, somewhat agree. I see 63, 64, 65, 68, 72, 73, 74, and 75. And now the 1s, strongly disagree. All right. We got a couple more of those, okay? So just be ready for those scale questions. All right, and we actually just talked about this, why motive is not an element of murder. So let's talk about some of the elements individually. So we've got the element of intentionally or knowingly, which I think we kind of talked about it a bit with number 37, 31. Okay. So paragraph A is alleging intentionally or knowingly caused the death, right? So we got up here on the screen the definitions of intentionally or knowingly. Intentionally, if it's your conscious objective or desire to engage in the conduct or cause the result. And then knowingly, if you're acting knowing that the conduct is reasonably certain to result. So let's talk a little bit about the difference between those two. Got a mosquito there. Oh, no, I'm sorry, there's no mosquito. But let's say there was a mosquito there, okay? So if I just slam on the mosquito on the table, killing it, does everyone think I was intending to cause its death? Yeah, all right. Now let's say, got a mosquito, I don't like mosquitoes. Say I take this, and I'm not slamming it down, but I just drop it on top of the mosquito. Now, if I'm doing that, am I knowing that by letting go of this file, that it's probably going to cause the results of killing the mosquito? Yeah. Does anyone have any questions about the difference between intentionally or knowingly? No? Yes, sir. Number 38.
While you just dropping it like that.
Yeah.
People might have had a chance to get off from under there.
It might, right?
All right, I'm sorry, we cannot hear.
Oh, I'm sorry.
So everyone remember, if you're not on this row in the box or that front row, if you could stand and make sure you keep your voice up so that the court reporter can hear.
So, sir, if you could repeat your answer.
Okay. At first you slammed the pad on there, but the next time you just let it drop, that's giving the mosquito time to get off from under there, so that's the way I see it.
Right, no, that's very true. That's why there's a difference, right?
Right.
It can be intentionally or knowingly.
Or none, so you wasn't intending to kill the mosquito, you just wanted to fly off before they hit.
Right, so the first time I was definitely intending to kill it.
Right.
The second time,
Time you wasn't trying to kill it, you just wanted it to scare it or let it
Well,
get away from it.
well, but did I know that it could result in the death of the mosquito if I did that?
Yes,
Because
you
what
did.
if that
Yes, you
mosquito
did.
doesn't follow? No,
You
sorry.
didn't know it could kill the mosquito, but you wasn't trying to kill it.
I wasn't intending necessarily, but I knew that could result, right?
Right.
I knew that it could result. Thank you, sir. Yeah, I appreciate that. So I mean, then we're kind of getting, when we talk about intentionally or knowingly, we're kind of getting into the same stuff we talked about before, right? About trying to get into the mind of the defendant. So how do we prove intent? Let's see, number 5, I think. Is that, sorry, I'm Jason Jorgens.
I'm Nathan, how are you?
I'm good. Why are you shaking my hand?
Hey, you held out your hand.
I did, but I didn't say that I wanted to shake your hand.
Hey, you're right, I guess.
Right,
Yeah.
but that's a normal
Yeah.
response, right?
Yes,
When I'm introducing myself and I hold out my hand,
yes,
you
my
expect to shake
normal
your hand.
response is to shake your hand.
Sure.
Yes.
yeah. Then ma'am, number 6. Would you mind shaking my hand too? Oh, no, you don't want to shake?
Yeah.
Oh, I'm sorry.
Yeah.
Number 7, would you mind? All right, thank you. ma'am. I appreciate that. So with number 5, I didn't say anything, right? I didn't say that I wanted to shake his hand, but that was the intent, right? That's what I clearly intended from what I did. Number 7, I talked with her about it and I said, that's what I want to do. I want to shake her hand. Those are generally the 2 ways that we prove intent, right? Either the words or the actions. So what kind of actions might a defendant take following a crime that could indicate intent? Following a crime, so after it happens. Any questions? 26.
I mean, how to prove intent, I think, is how, like what led up to the incident. That's how we, in my opinion. how we
Sure,
prove
yeah, it could be things before the incident, right? So if, what kind of thing, what do you think might be leading up to the incident that could show intent?
If it's murder, I mean, robbery or, something went
Sure.
wrong or just, this day and age, anything can happen, something so little could
Sure.
happen, could be a little so big.
Well, because I kind of glossed over it on my last slide. Oops, that's going backwards. There. But so right under intent could be formed in an instant, right? So possibly, like what you said, during the course of a robbery, you could decide at that point, I'm going to murder that person. So theoretically, yeah, something that's leading up to it could. What about it right after the incident? What could happen right after a crime, not necessarily murder, but any crime that could indicate someone's intent? Number 32.
Trying to cover it up.
Sure. Yeah. What do you do after? If you're thinking that you might get caught or something, you might try to conceal evidence, you might try to run away, anything that kind of distances you from that incident, right? And sorry, sir, I think I saw your card as well. Did you have something else or same thing?
Run away, yeah.
Oh, run away. Yeah, sure. All right. Does anyone have any questions about intent or want to talk about it? All right. Let's talk about the element of deadly weapon. Now, in Texas, deadly weapon is a defined term. So one of the definitions is just a firearm. And you heard from discussing the elements, that's what we've alleged in this case, that a firearm was used. So under Texas law, a firearm is just automatically a deadly weapon. You can see through the struck out language, there are other ways to prove that something is a deadly weapon. But a firearm, if we prove that a firearm was involved in this case, that is a deadly weapon under Texas law. Does anyone have any questions about that? No? Yeah. So let's talk about the element of serious bodily injury. Because remember in the second paragraph, you can not intend to cause the death, but you can intend to cause serious bodily injury. Committed acts clearly dangerous to human life that resulted in death. The serious bodily injury is defined as well. It just means some kind of injury that creates a substantial risk of death or causes the death or serious permanent disfigurement, protracted loss, or impairment of the function of any bodily member. So if you're just intending to cause serious bodily injury, you commit an act clearly dangerous to human life, and it results in the death, that's still murder in the state of Texas. Does anyone have questions about that? No? All right. So let's talk about what kind of evidence you would expect in a murder trial. Does anyone have any suggestions about what kind of evidence might be presented in a murder trial? Number 55. Yes.
Fingerprints.
Fingerprint, sure. What else? 56. Video, sure. 27.
You're saying murder of body.
Can't hear you, sir. If you could please stand up.
We're saying murder of body.
Yeah. Yeah, hopefully we can find a body, right? If we're alleging murder. And sir, your card's backwards. 26.
I mean, like bullets, like shells.
Sure, shell casing, sure. Now, shell casings, what's the significance of shell casings?
To match the gun and then have to
Sure.
match guns.
Yeah, they could be,
Sorry,
oh, I'm sorry.
match, to match the gun and the.
To match the gun to the owner, match fingerprints. See if the gun was registered to.
Sure. All right, and number 23.
I was gonna say. Person that was accused of murder. Actually purchased that gun belongs.
Sure, yeah, some kind of connection to a gun. 38.
DNA.
DNA, sure, I could, again, we're talking about hypothetically, what evidence could be presented. 66.
Police reports.
Police reports, so that's actually interesting. So under the law, police reports are not considered evidence. Do you know, why do you think that might be? Why might police reports not be used as evidence? Have you ever watched the Johnny Depp Amber Heard trial? Did you watch part of it? Did you hear all the lawyers standing up and objecting to hearsay? Yeah, you're probably gonna hear some of that during the trial. So hearsay is basically some kind of statement that's not admissible in trial. But do you know why we don't like hearsay? Why we would not use a report? Because who wrote that report?
A police officer.
Right. So wouldn't you rather hear from the officer himself or herself? Yeah. So that's the general idea behind hearsay and some other rules of evidence is that we try to put on the best evidence that we can. And generally, you'd want the officer who wrote the report because the report may help him remember or her remember what happened. But ultimately, the officer is the one that experienced it, right? And that actually brings us to the second half of what I was trying to get at. Generally, two types of evidence for any kind of trial. It's either physical, which is kind of what we were all talking about with fingerprints, shell casings, a gun, body, and then witness testimony. So the officers who responded, maybe other witnesses who were present, right? Anyone have questions about that? What kind of evidence could be presented? Because we're only, yes, sir, number one.
Maybe like a.
Shows trauma to the decedent?
Yeah.
Okay, sure, yeah, potentially to show, I think you're kind of getting at like the cause of death, is that, okay. Yes, sir, number 26.
You could use like video forms, right? If there's like video evidence.
Sure, there could be video evidence, yeah, and 25,
Say like, I should buy like some of the.
the time of death based on the autopsy, is that, sure. So yes, I agree, all of that could potentially be evidence, we're only talking in hypotheticals right now. But what I'd like to get at is the law, the legislator does not require us to prove a case in a particular way. Our burden, like we've been talking about, is proving a case beyond a reasonable doubt, proving every element of the case beyond a reasonable doubt. The law does not say how we have to prove it. So it doesn't say you have to give a particular type of evidence to prove this element, as long as we can prove every element beyond a reasonable doubt. So what that means is, and I forgot who said it over here, DNA. If there's no DNA at trial, or if there's no casings at trial, hopefully we have a body, whoever said body, hopefully we've got that. But if there's not a particular kind of evidence, but we still prove every element of the case beyond a reasonable doubt, the law still requires you to return a verdict of guilty. Is everyone comfortable with that? Does anyone have any questions about why that might be? Why a particular type of evidence is not required? I'm not seeing any cards. Yes, ma'am, number 58.
Because every scenario or situation is different. So
Sure.
to expect it, a set of requirements for every case.
Right, exactly. And that was another card over here. 32, yes, sir.
Circumstantial evidence?
And I'll get to that in a second. Hopefully I don't run out of time here, but yes, I will get to that. We'll talk a bit about direct versus circumstantial evidence, all right? How many of you guys watch like Law and Order, CSI, those kind of TV shows? Yeah, I see a lot of cards over here. Who have I not talked to yet? Number 9, sir. So in those, I don't know, which kind of show do you watch? Or which time?
Law and Order.
Law and Order, right? So I mean, they've got their detectives like doing like zoom and enhance analysts on the photos, like zooming into like 1 pixel, and then they can find a fingerprint on that, right? Stuff like that. Like they get pretty wild with. I'm sorry, you can sit down. I appreciate it. They get pretty wild with their detective work, right? do you expect that kind of work in real life, like that kind of, hopefully? I mean, it would be great if we had that kind of technology, and that kind of resources, but I mean, ultimately, we're gonna be limited by what is possible in the real world, right? Is there anyone that would hold us to those TV shows where they get a satellite view, they somehow go back in time to see on the day of the murder, the satellite took this image? Is there anyone who's expecting that kind of, that fantastical, number 30, you're expecting that kind of evidence?
Maybe in a few years, AI.
Well, hopefully.
is it?
Yeah, I mean, the AI stuff is actually really interesting with regards to photo enhancement. That's gonna be a very interesting impact on the shape of the law. But as of today, are we at that point with AI? AI is having trouble like drawing hands now, right? Isn't that, I think that's what I've seen in some of the pictures that are coming out. Oh, I'm sorry, number 43, yes, ma'am. Sure.
I mean, nowadays, there's cameras and on traffic lights, there's
Sure.
cameras everywhere. So, really, I mean,
Sure. Where do you think crimes typically happen? Do you think they happen at a traffic stop? Like they happen everywhere, right? Sure. Would you expect there always to be cameras everywhere?
we expect them, but most places do.
Okay. What about your home? Do you have cameras inside your home? Okay. And are they always recording?
Yes.
Do you expect that everyone has cameras in their home that are always recording?
No.
Okay. So, again, would you require that? Do you think that because you have cameras in your home that are always recording, that everyone should, and if you don't see that, you wouldn't be able to consider anything?
We make them already.
Sure. Yeah, no, obviously, we want to present all the evidence that we have available, right? But we got rules that we got to follow, right? So just like number 66, just like we were talking about, there are rules of evidence for what can be admitted and what can't be. Now, we as lawyers, we've had to say that for years, right? And and ultimately, the judge decides what gets admitted into evidence. So, is there something that you would require, like some piece of evidence that, even if the judge says it's not coming in, you said I can't return a verdict without this particular piece of evidence? Okay. Does anyone else have questions about that, or anyone want to expand on that a bit? Yeah. All right. So the judge talked about the one witness rule, right? If a single witness proves every element of the case beyond a reasonable doubt, then in that situation, we've met our burden. Because again, the law does not require us to prove a case in a particular way. Yes, sir.
You said that the can't provide the police officer statements, right?
The written report, yes, sir.
You go by the CSI then, or did they do the report too?
Sure, the CSI would have report. Sure, but would you want to hear from the CSI instead of the report? Sure, right? Yeah, so we can bring in live witnesses for that kind of thing, just not the reports that are written. The reports are to help them remember what happened, and for us to review, for my office to review, for the defense to review, so we know what kind of questions to ask. All right, so let's go to the one witness rule. We got another scale question here, and I'm going to try to go through it as quickly as I can without setting anything. If you believe all the elements beyond a reasonable doubt, you would be able to find Mr. Guzman guilty of the offense, even if all of the elements were proved through one witness. So I'm going to do this. We're running a little short on time. I'm going to do this as the entire group. All right. So when I call out your number, you can lower your card. That way I don't double count it. So the statement is, we've proven the case beyond a reasonable doubt. We've proven every element of the case beyond a reasonable doubt, but all the elements were proved through one witness. And you would be able to find the defendant guilty. So for that statement, strongly agree is number 5, somewhat agree is 4, don't know or no opinion is 3, somewhat disagree with that is 2, and strongly disagree with that is 1. Yes, sir. Number 20.
Is there an assumption before you make the decision that
Witnesses. applicable.
Yeah, so it's the judge's hypo. Yeah, judge's hypo. You believe that witness beyond a reasonable doubt.
Okay.
All right, let's have all the fives raise their cards, please, and I'll give you a few seconds for that. Everyone who agrees with number 5, strongly agree. All right, and keep your cards up or waffle them. No, okay. Everyone's got their cards up. So when I call out your number, if you can lower it, and start in the back, if you can. 1, 3, 6, 9, 10, 11, 12, 13, 17, 19, 24, 29, 32, 33, 34, 37, 38, 39, 40, 42, 43, 45, 46, 56, 58, 61, 62, 65, 66, and 71. All right, everyone agree whose opinion is number 4? Someone agree with that statement? Give you a couple seconds. All right. 2, 4, 5, 7, 8, 15, 16, 18, 20, 22, 23, 30, 31, 35, 36, 41, 44, 47, 48, 49, 50, 51, 52, 55, 57, 60, 63, 64, 67, 69, 70, 72, 73, 74, and 75. And now the ones don't know or no opinion on it, the 3s, if I can get you to raise your cards, give you a few seconds. Numbers 26, 27, 53, 54, 59, and 68. And now 2s, somewhat disagree. Number 14, 21, 25, 28. All right. And now the 1s, strongly disagree. I'm not seeing any cards for that. All right. So let's go kind of to what we were talking about with, I'm sorry, ma'am, what was your number? 43? So let's say that you were robbed, and I hope that never happens, but let's say that you were robbed. Which of these 2 places would you rather be robbed at? Would you like a dark alley or a stadium with hundreds of thousands of people watching? Okay. Why is that? Right, you got a lot of witnesses, right? Now, going back to what we were talking about earlier, who chooses where a crime happens? Nobody chooses? You as the victim don't get to choose. Who does choose?
The perpetrator would.
The perpetrator does. Yeah. Right, so when we talked about before about what kind of evidence might be available and what kind of evidence we could bring to you, we're kind of limited by where the offense happened, right? Is that fair to say? Okay, that's a yes? Okay, I'm sorry, I'm just trying to get it clear for the record. I've got a verbal answer. All right. Now let's talk about who we'd like to be a witness, right? So we'll set aside the stadium full of football fans. Who hasn't talked before? Who would like to talk about this very complicated question about who you would like to have as a witness? Number 72. Yes, ma'am.
Yes.
All right, so let's talk, and I forgot, who was asking about circumstantial evidence before? Is that, and what's your number? 32? All right, let's talk about direct versus circumstantial evidence. It sounded like you at least knew the buzzword for it. What's the difference between direct and circumstantial evidence?
Circumstantial evidence doesn't so much prove, well, there's no direct evidence that it was you.
Sure. So let's talk about up here, the pictures up here. So on the left-hand side, we got Six Flags during kind of a bright day. Let's say that the next day you come back and it's you got all the snow covering every place. So what would be the direct evidence? What would be direct evidence that it had snowed that night?
The snow on the building.
Well, so if you didn't actually see it, is that direct evidence? Right. Yeah, because, and this was right where you're shaking his head. So direct evidence is something that you see, or maybe if someone took a video of it snowing, right, showing the snowfall. That would all be direct evidence that it happened. That kind of goes to what number 43, I believe, was talking about with having video of something happening. But if you go to Six Flags one day and it looks like a picture on the line, and then you go home because you've had a good day, but you want to go to Six Flags again because it's a lot of fun. And you go back the next day and it snowed, or you see a bunch of snow everywhere. You didn't actually see it happen, right? You don't have direct evidence that it snowed that night. But what can you infer from the circumstances of what you're seeing at Six Flags?
That it had snowed.
Sure. Now it's possible, theoretically, right, that someone came in with a whole bunch of ice machines and they wanted to be festive for Christmas in March, or still in March. They wanted to be festive for Christmas in March, and they went in with a whole bunch of ice machines and blew snow everywhere. And that's what you're seeing the next day, right? It's possible, theoretically. Is that fair?
Yes, sir.
Is it likely? Is it probably reasonable to think that? Right. No. Most likely the reasonable explanation is it snowed that night. It's an inference that you can make from the circumstances of what you're seeing. Is that right?
Yes.
Okay. So going back, the law does not require us to prove our case in any particular way, as long as we've proved each element of the case beyond a reasonable doubt. So what that means is it can be proved through direct evidence, circumstantial evidence, or a combination of the evidence, as long as all 14 of you are satisfied beyond a reasonable doubt as to every element of the case. Let's do one more scale question about that. If you believe the case beyond a reasonable doubt that the defendant's guilty, even if there was only circumstantial evidence, but that circumstantial evidence was strong enough that you believe every element beyond a reasonable doubt, you would be able to return the verdict of guilt. All right. Does everyone understand the question or the statement? Everyone know the scale at this point? All right, seeing a lot of nods. Let's see the cards for number 5. Strongly agree with that. I'm seeing on the couple seconds. All right. I see 3, 6, 7, 20, 21, 23, 24, 29, 32, 38, 40, 46, 56 thinking in there, 58, 60, and 63, 64, 66, 71. All right, the 4s somewhat agree with that statement. We got 1, 2, 4, 8, 9, 10, 11, 12, 13, 16, 17, 18, 19, 22, 30, 31, 34, 37, 41, 42, 43, 45, 47, 48, 49, 54, 57, 62, 65, 69, 70, 72, 74, and 75. And now the threes, don't know or no opinion about it. Number 5, number 15, 25, 28, 33, 35, 50, 51, 52, 53, 55, 59, 67, 68, 73. And somewhat disagrees of the twos. 14, 30, is that 36? Are you 36, 39, 61, and the ones strongly disagree with that statement. 26, 27, 30,
No.
oh, okay, sorry. 44. And all right. Told you there'd be a few of these, right? All right, so now let's talk about murder and just violent crimes in general. If there's something that you're not comfortable talking about in front of your 74 new closest friends, we can call you up after this process is over. So I'm not trying to put anyone on the spot, but if you're comfortable talking about it, we'd like to know a bit about what happens if it's relevant to you. So if I can see just right now, just a show of cards, we won't talk about it at this point, but just a show of cards. If either you or someone that you know has been accused of a violent crime. And I'll give you a couple seconds to get your cards up. All right, I'm seeing number, yes, sir.
What about a victim of a violent crime?
That's 26. I'll get to that in a second. Right now, I'm talking about whether you or someone that you know has been accused of a violent crime. Someone you know being either a friend or family, just accused of a violent crime. All right, so number 2, 14, 19, 23, 27, 31, 32, 34. Oh, I'm sorry, 23, did I miss you? 23? Oh, okay. 34, 35, 36, 40, 41, 46. Just 1 second, sir. 54, 60. Okay, yes, sir. I'm sorry, what?
Accused by who?
Accused by anybody. State of Texas or individually. 45. All right. Now we'll get to, sorry, I forgot whose question it was, but if you or someone that you know, again, friend or family, has been a victim of a violent crime, if I could see a show of cards, please. Couple seconds. All right. Number 6, number 11, number 12, number 14, number 24, 25, 26, 27, 32, 33, 34, and 29. I'm sorry, I missed you. 29, 35, 36, 39, 41, 43, 46, 52, 59, 60, 61, 63, 64, 65, and 69. All right, so let's go back now. Those of you who have been accused or know someone who's been accused of violent crime, anyone that's comfortable talking about that, can I see a show of cards? And we'll just talk about it briefly. Yes, sir, number 2. Who was accused in your situation?
I had a first cousin that he's a foreman and somebody stole from him. And he was, I think, convicted of a violent crime towards the guy that stole, and he beat him, did it to death, put him in the hospital.
Okay. So would that affect your ability to sit as a juror on this case? Do you think you don't think it would influence you on this? Okay, thanks. Number 19. Yes.
I raised my card because I want to make sure that I should have raised my card
Sure.
prior. My brother was charged with armed robbery. I don't know if there was no actual violence that occurred and no guns were fired.
Okay.
But I don't know if that's violent.
Okay. Yeah, well, I appreciate you being sure. Yeah. Would that affect your ability to sit on this case? Okay. Number 23.
Jason, I can't hear you.
Can you speak up a little bit louder?
When I was young, I had an uncle who was 16 and shot another 16 in the face.
And would that affect your ability to sit on this case?
I don't think so.
Okay. Thank you, man. I appreciate it. Number 30.
I didn't raise the first time because I wasn't totally sure, but yeah, so I had an experience where I was really, really young, but my parents went through custody battles and whatnot. My understanding is, I've been told that my mom accused my dad of a bunch of domestic abuse and things of that nature. I was really young, so I don't really know for sure, but it probably happened.
Okay, I appreciate that. And would that affect your ability to sit as a juror on this case?
I don't believe so.
Okay, I'm running very short on time. So I'm sorry I don't have a chance to talk with all of you, but if you can raise your cards, for those of you who you've been accused or you know someone that's been accused, if that would affect your ability to sit on this jury, like you don't think that you could be fair and impartial to either side because you or someone that you know has been accused of a crime. And I guess beyond just, you don't think, you are sure that you could not be fair and impartial just because of the nature of this case, like the burglary of a vehicle that we were talking about at the very beginning. Number 40, you couldn't be fair and impartial just because of your experience.
Right, I've had several experiences, like you said, about a burglary, or vehicle was burglarized many years ago, and I just felt invaded.
Sure.
And then also I had a cousin when I was younger that was actually murdered at a party.
I'm sorry.
So, I mean, there's been several events, and then I had a friend that his son was accused of a sexual assault.
Okay. So you cannot be fair in
I
this
think
case.
I'd be able to be fair, to be honest, and I would want I would want him to have a fair trial.
Sure.
I don't think I mean, hearing the evidence and everything, I would want him to have a fair trial.
Sure. So I'm sorry to keep pressing you, but we need an answer, yes or no. You cannot be fair. in this
No,
case.
no,
Okay, thank you, ma'am. I appreciate that. That was number 40 and 36. Same question. Could you be fair in this kind of case?
No.
You could not. Thank you, ma'am. I appreciate that. And I'm sorry to go fast. I'm running out of time here. Number 54. Yes, sir.
Yes, it was due to my parents and I hold my father against he did the shooting.
Okay. So you cannot be fair in this case. Okay, thank you, sir. I appreciate that. And that was 54. Okay. And how many else agree with? Nope. All right. So now let's go victims of violent crime. Either you or someone that you know has been a victim of a violent crime. And because of that, you could not be fair and impartial in this case. If I can see a show of cards, those who could not be fair and impartial because of that experience. Number 6, you cannot be fair just because of that experience. We don't have time to get into it.
All right, so you're talking too fast for the court reporter. I understand that you're running out of time, but the record is not happening because you're talking too fast for her.
Okay, I'll try to slow down. So number 6, you cannot be fair in this case.
And I don't believe so. My son was carjacked and shot at 3 times at gunpoint. So I don't believe when it's pertaining to a gun, any kind of shooting. I don't want to take away from him having a fair trial.
And I know you don't think, I'm sorry, we have to nail you down to an answer. Could you be a fair juror in this case?
I don't believe so, no.
We have to get a yes or a no, unfortunately.
No.
You cannot be fair.
No.
Okay, thank you. And it's not to say that you couldn't be fair in another kind of case.
Yeah.
We're talking about this particular case. All right, agreeing with number 6, could not be fair in this particular case. 25. Could you please stand, please? Could you be a fair juror in this particular case? No, thank you, ma'am. 26, could you be a fair juror in this particular case?
No, sir. I had one of my best friends got carjacked and killed last year, so. Yeah.
I understand. I'm
All
sorry
right,
about that.
let me pause you for a moment. Here's the question, everyone. Everyone has had things that have happened to them, right? The question is whether or not you will be able to sit on this jury if you're selected on this jury whether or not you will be able to base your decision on the evidence that you hear that's presented to you. That's the question.
Yes, I understand everything, and also like, that's why I didn't agree on some of the witnesses. But no, I don't, yeah, I won't be, it can be, fair.
Thank you, sir. That was 26. 52, same question.
No, I can't.
Okay. And 59, same question. You cannot be fair. You cannot consider just the evidence presented in this case. That's yes. That's no. Okay. And I can hear in
But you have 1 minute, 27 seconds.
All right, Judge. Well, now I'm gonna have to start talk fast.
Yes, you keep it 29.
Oh, I'm sorry, did I miss? 29, could you be fair in this case? Okay, thank you, sir. Let's skip over the scale questions, so you guys don't have to worry about those. Is there any other reason why you do not believe that you could be a juror for this case? Because of religious reasons, you can't sit in judgments, because you know one of us and that would affect your ability to sit as a juror in this case, or any other reason why you cannot be a juror for this case. If I can see a show of cards that I will call out very quickly. Any other reason that we have not talked about so far that? Yes, sir, number 4. And 52 and 70. Number 4, as quickly as you can. What is the reason that you couldn't be?
I have like a pinched nerve, and sitting here would distract. I won't be able to concentrate on what they're saying because I really want to stand up and stretch.
Okay, have you been having trouble concentrating just
Yes,
sitting
I
for this?
mean, that's why it's squirt down and scoot up because I can. You're killing me here, and especially you couldn't find harder seats. I mean,
Well, I appreciate that. 52, yes, ma'am. What was the other reason?
I retired from the San from the 31 years of service and.
Okay, just because of your past experience, you couldn't be fair to both sides.
Yes, sir.
Okay, thank you. And was there someone else? Oh, there's one other one. Yes. Sir. Oh, for religious reasons or personal reasons? Okay.
All right.
Thank
Thank you.
I look forward to working with 12 or 14 of you.
All right, everyone, we are going to take a break. Here's the question before I let you all go. And this break will be about 15 minutes. Do you all want to take a lunch break or do you want to come back in 15 minutes? All right. So what we're going to do is we're going to come back at 11. Let's make it 11:50. Here's the thing. Everybody needs to be lined up at that side. If you need to go to the restroom, everybody doesn't have to go to the same restroom because I know sometimes people will see a line. Wherever you see the stairs, on either side of those stairs are restrooms. So you can go all the way from this floor all the way down and you'll find restrooms. If you want to get a quick drink, there's the cafeteria in the basement. All right, so we'll be back at 11:50. Everyone, please rise.
Yeah.
Almost, you all had to go to the school, you really need to get your role, I think it's
Hi, jury number 29, come up for me, please. Hi, you haven't done anything improper, but the deputy informed me and I informed both the state and the defense that you said that you may be that you are a witness on a murder case.
No, it's not a witness. I raised my card because there's a case pending that involved my nephew who was murdered. And it's been a little bit over a year. So it's the kind of healing through the process and through the healing process and they're still going to trial. The person has been gets indicted.
All right.
So, kind of sits in the back of my mind, and I don't want you to think I just want to get out.
Oh, no, I appreciate your telling me that, but let me ask you this. If you were selected on this jury, would you be able to base whatever decision you would come to in this case, if you can come to a decision based upon only the evidence that you hear in this case?
I'm comprehending everything we're discussing, but kind of going back to what took place, and it kind of feel like I probably wouldn't be fair to the individual.
Okay, so I'm going to give you an example that I used to use when I was a defense attorney and a prosecutor. When people would tell me they think so, here's an example for you. If you're going to Vegas and you tell your significant other, oh, I'm going to Vegas, and your significant other says, that's great, enjoy, have a great time. And as you're leaving out the door, your significant other stops you and says, hey, are you going to cheat on me when you're in Vegas? And you say, I don't think so. Would they accept that as an answer?
No.
All right. So in this case, it just needs to be a yes or no. No answer that you give is the wrong answer. Every answer that you give is the right answer. So would you be able to be fair if you were selected on this jury? All right. Thank you so much. Thank you. All right. So are both sides ready to bring the jurors in? All right. And defense? All right, so defense, are you going to want to ask any more questions of juror number 29 at the panel? Okay, so we'll just avoid those questions. All right, are both parties ready?
Yes.
All right, let's bring them in. You know, when we would go to CLEs, they did the Colorado method, which I don't like. Which one's that? Oh, it's where you assign numbers to jurors, and then you add them all up. And,
Yeah, I'm gonna follow up on the
Colorado method for jury selection. Mhm. But the only problem with that, when you're dealing with 70 or 80 jurors, it's hard to keep track. Especially, you know, in Bear County, if you're a defense attorney, you're sitting by yourself. But
It was literally,
every time I would go, they would say, use the Colorado method.
she was like general specific all at the same time.
Yeah.
And everyone was coming out. And then, you know, it was so, did you pick any juries down there? They knocked it down to like 85 chairs. There were pillars in the back. Oh. Yeah.
It's super hot out. Chilly.
All right, everyone, please be seated. All right, defense, are you ready to proceed?
I am, Your Honor.
All right, you may proceed.
Please support. Ladies and gentlemen, we see a show of hands. Who here has not answered any questions? Come on, somebody had, I'm not talking about the numbers. Who here hasn't like given an answer about themselves or hypotheticals? Okay. Anybody ever go to SeaWorld? You know what the splash zone is? Right? So the people who haven't talked are in the splash zone. Like the judge says, what we're looking for are answers from people about your opinion. Like the judge said, there's no right or wrong opinion. We just need to know if you're the right kind of person for this case. And if you don't say anything, we're never going to know. And I will tell you one time when I was a much younger lawyer, we had somebody who was mentally impaired who ended up on a jury because they sat there and never answered a question. But that is not uncommon. What's the number one fear? Public speaking. Okay. So as my wife always says, I like to talk a lot. Like most lawyers, we don't listen very well. So who here has any questions for me about the process or would like to share with everybody here what you think about jury duty? Number 14. Did you stand up there? You go.
Yeah, I feel a little pigeonholed by your process. I'm just gonna put it out there. I don't have any influence on, how he, punished for the crime. That's cool. That belongs to the judge. But I'm also being put into a position where, hypothetically speaking, this kid walks in on a stepdad that's been molesting him. He's molesting the younger sister. This kid goes into a rage, shoots him dead, and it happens to be the molester's best friend who witnessed it. Okay, without a single shadow of doubt, kid committed murder. Hands down, done. And I'm now supposed to let the state of Texas go assign to him. He definitely did it. We have a witness. We know he did it, hands down. And I, as a juror, feel that being pigeonholed into only identifying the crime without identifying the circumstances could put me in a position where I am giving someone some type of penalty without taking into any consideration why it's happened.
Did you go to law school? You should have.
And it's just, I can't sleep at night. And so
Okay.
I'm just gonna.
I understand that. And the way this process works is we can't tell you about the facts, right?
Right.
So all we're trying to find out is whether or not you're the right kind of person to sit on this case. So everyone heard juror number 14, right? Anybody else feel the same way? Okay, juror number 7. What do you think?
I think she put it really, really beautifully. I'm a psychotherapist, so my job is like to see the whole picture, so it gives me some anxiety. Even with like the unreasonable doubt, 100%, but then what if the witness isn't actually credible, or what if, all these what ifs, right? So
Mhm.
it's a lot of pressure.
Yeah, so the reason we ask you all these questions is we're trying to figure out your thought process. We can't give you specific facts of the case. So it's a difficult process, but it's the best one in the world. Okay, just know that hands down. Mexico recently tried implementing jury trials, and they discovered that it's rife with corruption. Before it was, they just had judicial hearings, and essentially you won if you paid the judge more money than anybody else because there were no juries. But Mexico is famous for the plomo of plata, lead or silver in the justice system. You take the silver or get the lead. That doesn't work here. So here, y'all are the component that makes this system work. Okay? So all we ask from you is just give us your honest answer and let us know if you're the right kind of people to be on that case. And following up on that, Jason had asked some people questions about either having friends or family who were charged with a violent crime or victims of violent crime. And some of you were able to give specifics about why you couldn't be fair. And I just wanted to follow up on that. So let's see, juror number 35. I think you had raised your card, correct? Yes, ma'am? Okay, would you stand up, please, ma'am? So you had a friend or family member who was accused of a violent crime, is that correct?
Yes,
Can you tell us who that was?
oh, my son.
Okay. And can you, would you feel more comfortable talking in front of the judge, or are you comfortable talking now?
I mean, I feel comfortable talking.
Okay, can you tell us what he was charged with?
Aggravated assault.
Okay, and did he end up going to trial, or did he end up getting convicted?
He was convicted, but at the same time, they're appealing it because it was, they went ahead and, it has to, in other words, when they convicted him, they're appealing the case because at the time they did that, they falsely accused him.
Okay, so would that experience with your son keep you from being fair and impartial?
I feel that, yes. they
Okay.
would-
So we have to get more of a committal, okay? There's no right or wrong answer, but it's either yes or no. So the fact that your son, you believe, was wrongfully convicted of a crime, would that make it so you would not be fair to either the state or the defense?
I wouldn't be fair.
Okay, thank you. And then I also have down juror number 36.
Yeah.
Okay. And you had also answered that you had a friend or a family member who was accused of a crime, is that correct?
Mother and son.
Mother and son, okay. Do you feel comfortable talking about it now?
Yes.
Okay, can you tell us what happened?
Mother fighting for custody of 2 children. I had to fight off her husband. For the children, she shot him 6 times. He still lived. But she went to jail. Got out, still got the children back.
Okay,
He eventually died 2 years later. She got all of us back eventually. Son had an intruder break into his home with 3 other males. It was a she. He was fostering her. He broke into his home and tried to steal things, and he shot one of the boys 3 times just recently.
okay, so you can't be fair.
Can't be fair.
All right, thank you, ma'am. And then also, when Jason had asked about people who were victims of violent crime, I think juror number 25. You had said that you couldn't be fair, correct? Okay, do you feel comfortable talking about it? Okay, would you rather talk in front of the judge? Okay. Okay, so I'm gonna kind of follow along with some of the questions that Jason asked. I'm not gonna go through numbers. I just want to get a general thought process from you, whether or not you agree or disagree, okay? And we talked about, the judge talked about the burden of proof, the right to remain silent and things like that, right? But it's difficult to answer a question. I mean, Judge Boyd's really funny, kind of intimidating, and people don't like jumping up and speaking. So. With the last couple together. So what I want to do is talk to you about some issues we deal with in trial, okay? So this first one is, I'm going to read it to you, give you a couple seconds to think about it. And I'm just going to ask you by a show of hands whether you agree, and then after that disagree, okay? So the first question is, I would need the defendant to testify before I could determine guilt or innocence. Okay? Everybody get it? So I could not determine guilt or innocence without the defendant testifying. We all talk about, burdens on the state, everything else. But some people can't, we always have this need, I want to hear both sides of the story, right? Okay, so the question is, I would need the defendant to testify before I can determine guilt or innocence. So who agrees with that? I know they're out there. Come on, people, don't be shy. We got to find out. You're going to be sitting with us for a while. Okay. Great. Juror number 65, 72, 73, 18, 21, 22, 25, 28, 29, 38, 41, 43, 44, 51, 52, 54, and 59. Okay, so I would say, does everyone else disagree, or are there some people who don't know? Let's do that. Who would say, I don't really know, or don't have an opinion? That'll be easier, okay? So that'll be, let me start here, make it easier. Juror number 4, number 16, 31, 33, 34, 35, 37, 39, 49, 53, 55, 63, 67, 68, and 70. Okay. Here's the next one. We've all heard, man, what number are you in? What's your favorite crime show? Okay. What else? Okay. So you ever heard the word legal technicality? Okay, what do you think that means? Okay. 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 Who else has an opinion what legal technicality means? Yeah, yes, ma'am. What number are you?
Oh.
Would you say that, please?
Not sure, but it could be something that maybe either the state or the defense. Then something was filed, like there's something.
Like a screw up, right? Screw like that on the TV shows, right? Oh, there was a screw up and a guy walked, right? I mean, I still watch crime shows, to be honest with you. I don't know why I'm kind of sick. Podcast, right? So we've heard that term before. Okay, he got off on a technicality. They hear that on the news. We hear it on TV shows, right? Everyone understand that term? So the question here is, too many obviously guilty people escape punishment because of legal technicalities. Okay, that's the question, and I'm going to ask you, agree or disagree? Everyone got it? You ready? Who agrees with that? That too many people get off on technicalities? Yes, ma'am. Too many obviously guilty people escape punishment because of legal technicalities. Ready? Who agrees with that? Okay. Juror number 4. Juror number 9. 18, 21, 22, 23, 28, 29, 33, 37, 39, 40, 41, 45, 54, 56, 57, 59, and 60. Okay, now this is my complicated question. Jason he's young and he's got some really good ideas. I'm just trying to, the other Jason, not this one. Jason too. I've known Jason one a long time, so I call him J1 and J2. So this is not overly complicated, but so the question is going to be, when you hear that a person is accused of a crime, how likely is it that that person is guilty, right? Okay. Because let's think about when you first walked in here, right? What was your first thought when you saw my client sitting there? Wonder what he did, right? That's the general thought process, okay? So, and the judge talked to you about, indictment, not being evidence of guilt. And that's nice language to use, but let's just talk about when you hear that somebody is accused of a crime, how likely is it you think that person's guilty? Okay. So the first answer could be not likely at all, right? Or that you don't believe it. Okay. The second one is very likely. Okay. So when you hear somebody is accused of a crime, who here thinks that because somebody's accused of a crime, it's very likely that they committed it?
I have another question.
Yes.
We don't know everything.
I know.
How can you tell us yes or no? How can we answer yes or no to that?
So-
question?
Because the burden of proof is on the state, my client's innocent until proven guilty. Right?
Right,
So as my client's sitting there, he's innocent, right?
right.
So the question is, and everyone has preconceived notions about the criminal justice system, right? And you hear people are accused of a crime, you watch it on TV, right? See somebody accused of a crime, and your natural inclination is to go, oh yeah, I probably did it. Okay?
Is it?
Oh no. So you tell me. If somebody's accused of a crime, do you think it's very likely that they did it if they're in court?
I don't think I can answer yes or no to that.
Okay, that's fair.
Yeah.
That's fair. So, and if you can't answer, just say I don't know, because that's one of my very sophisticated questions. Yes, you're number 26.
I agree with her because it's like one look at him and everyone's already assuming things just on those, like, we don't know anything. Like, also like motives, like, we don't know, we're not supposed to know that, but like you're assuming and already judging just off sight. And that's already not fair in general.
Well, that's the entire purpose of the question, because if you're making assumptions about somebody's guilt already, then then the system's not working right. Correct? Yes, sir.
Also, I think it depends on who's being accused. Like if it's a stranger, then yeah, but if you're someone you know, then you're like, well, no, I know this person. They wouldn't do that to.
Okay,
Or more-
so let me ask you a question. If somebody you don't know is accused of a crime, say they're in court. So you walk into the courtroom and you see a stranger sitting there. Is your natural inclination to say, yeah, he probably did it? Okay, and if it's a friend of yours, you're gonna say he absolutely didn't do it?
I mean, depending on the friend, because you know.
All right.
About the actor.
Okay.
I mean, you think that they're your friend.
Okay.
But somebody, you never really know.
So that kind of goes back to the entire point, right? So whether it's your friend or a stranger, they're all entitled to the same benefit of the doubt, right? Okay, so when you walk in here, the way the system works is, and like the judge said, I think there was a case one time where a lawyer slept through the trial. And it wasn't me. And like I said, the entire burden's on the state. If I do nothing, and you don't believe the state's got the burden of proof, you have to find Brandon Guzman not guilty, because as he sits here, he's not guilty. Right? And the state's got to meet that burden. So the question is, in your mind, who here says, man, if somebody's been indicted and come to court, they probably did it. And so be honest with me, because I know you're out there. My feelings aren't going to get hurt.
That's my initial thought, but I feel like my thought is incorrect.
Okay.
Because I believe in the justice system,
Okay.
but it's still, I think it's a human immediate reaction.
Okay. Who here agrees with juror number 7's very brilliant answer? Okay. Okay. So juror number 1, juror number 2, number 4, number 5, number 7, number 8, 9, 10, 13, 15, 18, 20, 28, 29, 30, 31, 37. Is that 34, 40, 41, 42?
I couldn't hear her.
Okay. God, I thought I talked pretty loud. I'm sorry. Okay. Would you repeat your answer?
I said my initial very human, like just immediate brain response is to just believe that he's guilty, even though I know that he technically is still innocent. So I don't like how that's my immediate response, but I think it's a natural human assumption. So I guess I don't know where that leaves me. Kind of
Okay.
flopping.
I'll follow up. Okay, 45, 44, 46, 48, 50, 52, 54, 55, 56, 59. Nobody over here? Oh, I'm sorry, number 20. Okay, so juror number 7. You said you don't like how that makes you feel, right? Because you had you believe in the justice system,
Right.
and your natural inclination when you walked in was to go, what?
There's a reason he's sitting there.
Okay, so the question is, for those people who answered that question, can you be fair? Can you actually listen to the evidence and make a decision based upon what you hear?
I believe I can.
Okay.
Yes.
And if you can't, okay, and so the question is, can you or can't you?
Yes.
Okay, so for those people who raised your hand, right? Can you be fair and impartial and listen to the evidence and make a decision based upon the evidence you hear and nothing else? That's it. Because the same benefit that you would want your family member to have, or your friend, or anybody else that you knew or loved who was charged with a crime, is the same benefit you're supposed to give my client. Okay? And if you can't, nobody's going to hold it against you, because we all have different opinions. We use the word prejudice around here, and not in a racial aspect, but we all have different beliefs, and we've all been through different parts of our life and different experiences, right? They're going to affect and color how we act here. And it's like the judge said, determine whether you're the right kind of person on this case. And if you're not, nobody's going to hold it against you. We would appreciate your candor and honesty if you told us. Okay, because it's important, it's vital. It's the most important part of this system. Is y'all talking to us and telling us, hey man, I'm not the right kind of person for this case. I mean, that's it. Okay. So who here raised their hand when I talked to juror number 7 about whether or not you thought somebody was guilty when you walked in there? Let's see a show of hands. Okay. So juror number 4, could you listen to the evidence and make a decision based upon what the evidence you hear?
No,
Okay, so you can't be fair.
no.
Okay, thank you, sir. Juror number 5,
No,
you can't be fair?
no.
Okay, thank you. Juror number 8. You could, thank you, ma'am. Juror number 9. Could you be fair and impartial? Okay. Juror number 10. Okay, juror number 13.
Yes.
Thank you. Juror number 15. Okay. Juror number 18.
I don't think so.
Okay, so remember we talked about getting a commitment, right? So if you can't be fair, just tell us you can't be fair.
No.
Okay. Juror number 20.
Yes.
Okay. Juror number 28.
Yes.
Juror number 29. No, okay.
Sorry, what was that?
No, on juror number 29. Juror number 30.
Yes.
Okay, number 31.
Yes.
Juror number 37.
Oh, yes.
Okay. I'm sorry, I skipped one. Juror number 34.
No.
Okay. Juror number 40. What'd you say?
No,
Okay, juror number 41. Juror number 42.
No.
Juror number 45.
No.
Juror number, I'm sorry, I skipped juror number 44. Are those yes? Juror number 46.
Yeah.
Juror number 48. Juror number 50.
Yes, sir.
Juror number 52.
No.
Juror number 54.
No.
Juror number 55.
Yeah.
Juror number 56.
Yes.
Juror number 59. And I think I have, is that? Juror number 20, I think. You already did, okay.
Excuse me just one moment. Do you need some water? Okay. All right, you continue, please.
Okay, so let's talk about some other questions. Who here thinks there are, you're number 7 again. Walk the guard. In law school, we used to call them the gunners. Like the really, everyone answer all the questions. Okay,
I'm just really on.
that's okay. I like it. I like it. It makes it easier, right? So tell me, what's your experience that you think makes you a good judge? What do you do for a living?
I'm a psychotherapist.
Hell, we go. Here we go. Perfect. So what do you look for to determine if somebody's not being honest? There clues you look for, or body language? What? Tell us about it.
Well, a lot of it is intuition, but I had to put more of an external description. It would be body language, where they're looking, if they're looking at you, if they're looking to the left, to the right, if they look engaged, talking to you, the way they speak, if they're, struggling to come up with something, things like that. Yeah, the way they present themselves.
Okay, perfect. All right. Who else? Who hasn't answered any questions yet? I'm right behind you. Blue shirt. Sir, what number are you?
53.
You haven't answered any questions yet, have you?
No.
Yeah. All right. So what do you think about, what do you look for to determine whether or not people are being honest with you?
A lot of the things that number 7 said, they're the way they interact with you, what they say, what they do. A country boy, I think you're only as good as your word. So I often don't form opinions until I have been around someone, been able to observe those interactions.
So when you don't have that benefit of a lengthy interaction, are you capable of making, or do you think you're capable of making, like, we call it a snap judgment, but a pretty quick assessment of somebody's honesty?
Sometimes yes, sometimes no. The reason I haven't answered a lot of questions and I've had an opinion every time is because I feel like, especially something that's important, you have to wait and see. You have to hear the evidence. I don't know if I would, and if it's testify another information.
Okay. What about if it doesn't just?
I can't give you an answer right now. I have no opinion. If it would depend on what happens during the trial.
Okay, I'm gonna have to follow up this. Okay, so we talked about the defendant's right not to testify, right? So you hear all the state's evidence, okay? The state rests. And you're thinking to yourself, man, I don't believe that. Okay, that's my hypothetical. Are you gonna say, well, I still need him to testify before I can make a decision about guilt or innocence?
It's hard to say, it would depend on the evidence that the state.
Well, my
presented.
hypothetical is you in your mind, I'm gonna get in your mind right now. My hypothetical is you listen to their evidence and you go, they didn't prove it. Okay, that's where we are right now. When they rest, they haven't proven the case. Okay, I'm required to do nothing. Okay,
Right.
they have to prove the case. So if they finish their evidence and they haven't proven the case, can you still find him not guilty if he doesn't testify?
Yes.
Okay, that's all I need. Everyone else feel the same way? Who doesn't feel the same way? Okay, because some people are like, oh man, I need to hear both sides of the story. Yes,
I feel like you said, you need the defendant to testify. It's more like, you would probably, you think myself, I would probably want them to testify. I mean, depending, like, sometimes people are nervous testifying because they've been through some, just very traumatic. And they may be, so like, it's like, yeah, they might want to testify, you want them to, you need them to, but they're scared to, depending on the crime. But like, I feel like you do need them to, just to get some closure of that.
okay, let's go back to my hypothetical. Okay. So I'm, in the crime shows, I mean, you get to see everything, right? So sometimes a lawyer goes, them with their client to testify. There are some people who have speech impediments. We talked about the biggest fear is public speaking, right? Okay. And people have, speech impediments, delayed reception, things like that. So in my hypothetical, and I want you to stick with my hypothetical, right? You listen to the state's case. Okay, they rest. And when they finish presenting all the witnesses, in your mind, they haven't given you enough, right? So at that point in time, I don't have to do anything. Okay. And if you don't believe their case, how are you supposed to vote? Guilty or not guilty? Page number 26.
If they don't testify.
Yeah, if they don't testify, but you don't believe the state's evidence.
They don't testify and I don't believe it, then I can't convict them. I can't.
Exactly. Right? Okay. And I noticed that we have a retired police officer and other law enforcement. We have a lot of people who have friends and family who are in law enforcement, right? Can I see a show of hands who has friends or family in law enforcement? Either. I mean. Okay, so let's talk about, you can put them down. Let's talk about friends and family in law enforcement. Juror number, what's your number? 69. Who do you know in law enforcement? Okay, just, it didn't say to tell you? Where does he work? Okay. What was he like as a kid?
He's very into the family.
Okay, so you didn't know him when he was younger. Okay, how about somebody who has a friend, has a relative in law enforcement that they knew growing up? Your number, I'm sorry, what's your number, sir?
27.
Would you stand up, please? Who do you know in law enforcement?
Father was deputy chief in Detroit, Michigan.
Okay, and were you around a lot of his friends who were cops?
Yes, my uncles.
Okay. What were your uncles like off duty?
Great.
Okay. Did you ever have any issues talking to them about honesty or things like that or credibility?
No.
Okay. Did you have any younger relatives who were in law enforcement or just the uncles and your dad?
Yes.
Who is
I have
that?
a nephew who's in the law enforcement,
And where's that?
Detroit, Michigan.
Okay, still. What was he like as a kid?
Great.
Regular person, right?
Yes.
Okay. And I guess, would you believe that just because someone's a police officer, they are automatically to be believed about everything, or could you make your own judgment about
No
Whether-
organized criminals in the police department.
Okay. Okay, I'm gonna sit down. I appreciate it. Thanks. Okay, who else has relatives in law enforcement? Number 45. Would you stand up, please? Who do you, what relative do you have in law?
Brother and nephew.
Okay, let's talk about your brother. Where does he work?
He's retired.
Okay, was it here in town?
Omaha, Nebraska.
Oh, and what about your nephew? Where is he?
The air marshal.
Air Marshal. Okay, what was he like as a kid? Get in trouble? Never?
Not that I know.
Okay, all right.
I didn't have. Close.
Did you, well, were you around him a lot when he was younger?
Yeah.
Ever tell me anything? So. I guess the question, I'm done. Does anybody here believe that just because somebody is a police officer, their testimony is to be given more weight than any other person? I think we used to feel that way, right? And can we all agree that we're gonna listen to their evidence and make a decision based upon their testimony and not the uniform? Okay, so really quickly, show of hands, who here has not answered any questions or said anything? I got 53, so you're good so far. Okay, so would any of y'all like to ask any questions or give your opinion about the criminal justice system or anything else? So we can kind of write something on that clean slate so we can know more about you. Number 57, yes, ma'am.
Bit confused. I'd like a little more clarity about the young lady. I didn't know whether it was a hypothetical when she talked about the molestation or what. So I don't want to go into that. But I have very strong feelings about certain things. So
Okay, what are they?
I'm gonna try and neutralize it.
You're happy, if it embarrasses you, we can
I'm
put, but if not,
embarrassed. I just don't
man,
wanna-
we're all pretty jaded around here. Don't worry about it.
I just feel very strongly about certain things, especially children.
Mhm.
The foster care system, I have issues with. We had a really nice judge yesterday morning, and she was very passionate about her project. I felt very strongly about that myself. 150,000 children just disappear each year. They're trafficked. I feel very strongly about how they're trafficked. I feel very strongly about pedophiles. I don't have any use for them at all. They can just kind of disappear and sit with the children.
Okay, and
maybe
I'm sorry, and Juror, what I can tell you is that was,
See?
no, you can speak, but that was her hypothetical. You had asked whether it was just a hypothetical. So that was just her hypothetical.
Okay, it was.
Yes.
Okay, then it has nothing to do with it.
Yes.
Wondering about that.
Okay,
But that's how I feel.
Yeah.
If that was true, okay, she said she didn't want to pigeonhole him. If he was here, hypothetically, that was his.
Yeah.
He was accused of, and it turned out through the evidence that he did it. Good on him.
Okay, and unfortunately, we can't tell you anything about. this.
Right, that I
Right.
understand.
So that being said, can you be fair and impartial?
Yes.
Okay,
Because I believe just because someone's been arrested doesn't mean that they're actually guilty of what they were arrested for.
perfect.
You have to listen to the evidence. I don't know how many people this is their first time,
being a juror, I was summoned, this is my first time being summoned in Texas. I have served and been summoned in the Pacific Northwest where I come from. So
On a criminal case?
a criminal case and a civil case, traffic court. I was called for the grand jury once, but
Let me ask you a question. On the
Yes.
criminal case, did you make it onto the panel?
yes, I did. It was a robbery in the second degree.
Okay, what state?
Oregon.
You reach a verdict?
Yes, it was trial was a week. They had various witnesses and we listened to all the evidence and we debated or deliberated about a day and a half.
Thank you, ma'am.
You're welcome.
Okay, any other questions before I sit down? Because you're gonna be stuck without anything on them. All right, thank you very much, ladies and gentlemen. Appreciate it.
All right, ladies and gentlemen, I'm gonna have you all step outside. The people who are in this box here, if you could please take your personal items with you. And we will call you back in and let you know who will be on the jury panel. Everyone, please rise.
Number there.
I'm gonna let you get it since you're.
Yeah. Yes.
You're gonna hit.
Yes.
Yeah.
This is the list. They've already agreed to. Yes, this is on the record. Oh, come forward, please.
Audible?
Your jurors 3 and 37? Right, 37? All right, when I asked if you all knew anyone, you both said you knew Jason Garhan? All right, so number 3, how do you know him? All right. Okay, and 37, how do you know him?
His ex-wife's mother is my mother's best friend, so we actually have their whole family. House, his daughter.
Okay, now I need to do a tree in my mind because you're saying the ex-wife's. Okay. All right, defense, do you have any questions?
I guess the question is, being known Jason, what a life I is. Can you be fair and impartial to my client, or is your friendship with Jason, or relationship with Jason gonna affect your ability to be fair and impartial on this specific case?
All right, juror number 3.
So you can be fair and impartial?
And all right, thank you all so much for coming in.
Thank you.
All right, and then Deputy Laura, the next ones. 21, 22, 38, 43, 44, and 51. Oh, come forward. Come forward, yes. All right, if I could start with 21 here. 22. 38. Come forward. All right. And then back here, if I could have 43. 44, right behind this gentleman, please. And 51 right here, please. Yes, right there. All right, so I want to ask you a question, and then both the state and the defense will have a chance to ask you each a question. All right, does everyone understand that anyone who's accused of an offense has a right not to testify? Does everyone understand? I need yes or no?
Yes.
Right. And as I stated before, people have many reasons why they will not testify. You know, sometimes people are afraid of public speaking. Sometimes their attorney may tell them there's no need. There are a host of reasons why people may not testify. But here's the question. When someone exercises their right not to testify, you cannot hold it against them. You cannot consider it as evidence whatsoever. Does everyone understand? All right. So in this case, if Mr. Guzman decides not to testify, is there anyone here who will hold it against him? Juror number 21. 22. 38.
Yes.
Okay. 43. 44. 51. All right, is there any other question?
I'd like to ask questions during number 22. So you seem positive in answering that. I guess the question is, if you hear all the evidence, would you require my client to testify before you can find him not guilty?
I'm sorry. So this is the question. You understand that everyone who's accused does not have the right to has a right not to testify. You understand that? They have a right to remain silent. Do you understand that? Do you understand that if someone decides not to testify, you cannot consider that as evidence whatsoever. Do you understand? So that means you can't hold it against them. Do you understand? So if the state presents their case, and based upon the evidence that the state has presented, you believe that Mr. Guzman is not guilty, are you going to say in your mind, I will not find him not guilty because he hasn't testified? All right, thank you. Defense?
Judge,
Oh, no, go to your next questions for your next jurors, please.
Judge, I'm gonna object to the court's questions. I think he committed and said he could not.
Mr. Maurer, go to your next questions for your next.
I have no
jurors.
question.
All right, any other jurors? All right, any other questions from the state?
Oh, I'm saying.
All right, thank you. Yo, you may step outside. Second. Mr. Maurer, I don't think you heard his answer. His answer to the court was that he would still require evidence from your client.
Was he on 22?
Yes.
So I moved to strike for cause 22.
Well, do you all agree on 22 or no?
Yeah, yes,
Do you agree on number 38?
yes.
All right. And so, Mr. Maurer, the other jurors, 21, 43, 44, and 51, you had no other questions for them? All right. So, Caroline, the other parties that are agreed to are jurors number 22 and number 38. All right, anyone else that needs to be called up by either side? All right, defense, anyone else you need to call up? All right, so these are the jurors that are agreed to for the record. 4, 5, 6, 7, 18, 22, 25, 26, 27, 29, 31, 34, 35, 36, 38, 40, 41, 42, 45, 52, 54, and 59. Any objections, state?
No.
Defense?
No.
All right, could you mute us, please? All right, let me see where that puts.
I don't care. It's like, you whatever you want.
And then they just went on the case. I was like, well,
Yeah. Well, that's the concern, right?
yeah.
Because it's like I have a couple cases, I'm like, well, I'll call Dan. You know, because
Yeah.
they're like, I don't know what to do. I'm like, well, I'll call Grant, you know, because the problem is they try to call him and they don't get it.
Yeah.
Let's bring them in.
You know, and everyone down there is freaking on fucking shadow. Hey, are they still?
I was like, I can
I think
understand.
it's like,
I'm a Reed's administration.
you know,
People get dumped like flies.
it's a bad sign when the Reed administration is a high water mark of performance. Imagine what fear would do.
Only to the front bench. Because the ones that are selected will be sitting on the chairs. Just have a seat anywhere.
Okay.
If you need help, I'll be more happy to give you a seat chair. Anywhere. Anywhere. You guys are too funny. You guys are like decisions. What?
Sounds good. Oh, yeah, compared to out there. Yeah, this morning.
Come on in, have a seat. Not everybody's gonna have a seat. There's two more chairs over here. There's one chair on this side. The front row. Not everybody's gonna get a chair. Those are excuses on your seats. We got more. It's okay, we got more. Okay, come on. First row right here. Come on in, first row. Right here in the bench, right behind you. Five, six. I don't think we have enough space unless you guys want to punch in. There's a seat next to those two gentlemen's face. Make room for your other friend. And not everybody's gonna have a seat. So. No. And everybody else just come on in.
All right, everyone, please be seated. All right, ladies and gentlemen, thank you so much for your service. We, of course, cannot have jury trials without fill in the blank. Jurors. I'm seeing if you all are still awake. So you should have a white sheet of paper that was left. Only take one. It's your excuse to show that you actually showed up for jury duty today. Remember to get your parking validated if you'll go to the basement if you haven't already done so, and they will validate your parking down there. Now, what will end up happening for those of you who are not on the jury, you will receive a check in the mail. When you get that check, you're going to be thinking, is this real? Is this not real? But then you're going to remember the great time you had in the 187 District Court, and you're going to know that it's real. So with that payment that you receive, you can do one or two things. When you go downstairs to the basement, you can donate it. And there are many organizations you can donate it to, or you can donate it to an organization that you wish to donate it to. Otherwise, it should be enough for you to come downtown and have lunch on not the touristy spots, but to have lunch, or either you can bring your own lunch and just enjoy the Riverwalk. You're always welcome in the 187 District Court. Courtrooms are open to the public. We're here Monday through Friday. The only places I sort of discourage people a little bit from going to is the Children's Court, because they want to try to keep that as confidential as possible, and also Juvenile Court. But this 187th is an adult court, so you're more than welcome to always come here. What I'm going to do now is I'm going to call the names of the persons who are going to be on this jury. And when I call your name, I'm going to ask that you bring your personal items and please take a seat in the box. Chance Chimonte. Alfredo Miranda. Oh, it's good. You were already standing like you knew. Chris Deitchik. Deitch, thank you. Myra Aldaba. Melissa Minica. I don't know if that's a hard C or not. Jordan Harris. Jessica Cantu. David Lemon. Abraham Dominique. Angela Hook. Ernest Garcia. Mary Simons or Simmons. Madison Bond. And Diane Owensick. All right, everyone else, you are excused. Thank you so much for coming. All right, everyone, please be seated. All right, so I'm going to give you all some instructions about this trial. First off, as I said before during jury selection, attorneys for the state, attorneys for the defense, and Mr. Guzman are not allowed to speak with you. So sometimes when jurors are walking in the hallway, they will see attorneys, and because now you feel as though you know them, you will say good morning. And then they may not say anything to you. It's not because they don't want to speak to you. It's just that they're not allowed to. In this courtroom, the temperature fluctuates. Sometimes it's cold. More likely than not, it's usually very hot in here. So if you want to bring a jacket, as I always say, it's better to have it and not need it than to need it and not have it, because we don't have any extra jackets. I realize that the chairs are very uncomfortable. And I've talked to the powers that be about that, and supposedly that change is going to come. It's been coming since 2019. So we have started purchasing padding for the chairs. So you will see pillows back there. If you want to bring them out, you're more than welcome to bring them out. With regards to breaks, if anyone ever needs a break, just let us know. Just do the break sign. Either I will see it, or counsels will see it, or the deputies will see it, and they will tell me that someone needs a break. What I can tell you is in this court, I try to stop us at 4:30 each day. The reason why I try to do that is so that you can avoid the traffic for 5 o'clock. The only exception to that is I don't like to stop in the middle of a witness testimony because I don't think it's fair to do that to either side, because I want everybody to get a chance to get their direct done and any cross if there's needed to be crossed. When you come to back on Monday, you will not report inside of this courtroom. Deputy Laura will show you where you will report, and you will report to the jury room. So what is going to happen is on Monday, we're going to start at 1:30. I have a docket in the morning. That's why we'll be starting at 1:30. Now, with regards to parking, everybody who works in this building and jurors park at the parking garage. So if you can imagine, no, it appears that nobody thought of that when they were building the parking garage. So you will have all the jurors who normally come in, that big group of jurors who came in with you, they will be parking at the garage as well. Now, since we're going to be starting at 1:30, sometimes people go off campus. That's what I call it, when they get in their cars and drive somewhere for lunch. So probably if you show up by 11:30, you'll probably be able to get a parking space there. We do have a refrigerator in the jury room. So if you want to bring your lunch, if you want to bring your breakfast, whatever snacks you want to bring, and you want to put them in the refrigerator, you're more than welcome to use the refrigerator. I don't expect this case to have any publicity or media, but if that happens, do not look at it. Do not watch it. Do not do any investigation about this case. Do not search for anybody's name. You're not allowed to do that. Everything that you need to know about this case is to come from inside the courtroom. Does everyone understand? All right. Now that you're going to be jurors for the 187th District Court, you'll have badges that say that. Please make sure that you wear those badges at all time when you're on jury duty around the courthouse. Of course, if you go home, you don't have to wear the badge, but you wear it here because there are a lot of trials that are going on. There are a lot of attorneys, and sometimes attorneys will know about cases and they'll be discussing things. And I don't want you to hear that. And I don't want attorneys not to know that you are jurors. So we're going to start on Monday at 1:30. Are there any questions from anyone? Oh, this is the first. Usually people start asking me questions. All right, then. So what's going to happen in it? Oh.
There's no way to tell how long the case lasts.
No, what I can tell you is with regards to jury trials, I usually get an idea once I start hearing the testimony, because believe it or not, when cases go to trial, judges don't normally hear the evidence beforehand. So when you're hearing evidence for the first time, usually that's the first time I'm hearing it as well. So once I hear part of the evidence, I'll be able to approximate a little bit about when we will be done with the trial. Any other questions? Yes.
Regarding the prohibition on media.
Yes. Yes. So don't do any research. Don't Google anybody's name because both parties want a fair trial. And again, everything that you need to know about this case will come from inside this courtroom and nowhere else. Yes.
Sorry, just for clarification, we're supposed to meet where we first were the central jury.
No, Deputy Laura is going to show you where you meet. So don't wait in the hallway. Don't come inside the courtroom. She's going to show you where our jury room is. And that jury room door will be open for you to go in. Any other questions about anything? Yes.
I just need one of those slips whenever, I don't know who has it.
Oh, that you were, yes. All right, we'll make sure you have that. And then Deputy Laura will get your numbers and she'll give you our contact number. So if there's any issue, you can call in and let us know. Yes.
So I know you don't have to answer this, but my boss is asking, like, how long to block me off on a schedule? Is there any way to give her an idea of an hour? I just tell her I don't have that information yet.
Let your employer know that I will know. I will have probably an idea by Monday. Yes. All right. Anything else from you? Don't be shy. This is the time. Okay. All right. So we'll see you all on Monday at 1:30. We cannot start at 1:30 unless everybody's here at 1:30. Okay. All right, everyone, please rise.
Yes.
Yes. Yeah. Because I just went.
Yes, thank you. All right, everyone, please be seated.
But did you get the nuanced question, from that juror?
Yes.
Got to do any research from here forward?
Yeah. Let me ask you all, how much time are you all asked? I usually don't put a time limit on opening, but does anybody anticipate the opening statement being longer than usual?
No, Judge, I'm planning to do a fairly short opening statement. Somewhere between 10 and 20 minutes, I would think.
Okay,
Get about an hour.
okay. And if there are any motions,
Judge, just the motion limited we discussed concerning extraneous conduct and then the issue as far as the ballistics evidence that the state was discussing, introducing.
all right, with regards to extraneous, anything extraneous, just approach?
Yeah, we'll approach first,
Yeah.
Judge. We also have a motion limiting on file that we'd like, I think it's on file.
Okay,
Otherwise, I'll file this weekend.
okay. Well, this is what I want you all to do. The jury is coming back at 1:30. So if you all can be here at 1:15, so we can make sure that there are no other motion issues.
I'm set with you on Monday anyway.
Okay.
And I've got a 13 defendant docket that day, so I'm not leaving the building.
Okay. All right, is there anything else? If not, I'll see everyone back here on Monday at 1:30.
Thank you, Judge. Have a good
All right,
weekend.
We don't have to come back till 1:30.
1:15.
Oh, sorry, you guys are back at one. Thank you.
I was just making, I gotta clarify.
Yeah. Hey, I was testing everybody.
Did you file it?